सेशन पे काफ़ी सारी चीज़ें किए हुए हैं एंड इनके पास काफ़ी वास्ट एक्सपीरियंस है हमारे साथ शेयर करने के लिए। सो आज हम जो ये ट्रेनिंग अपना बायोलॉज का, एक सोसाइटी कैसे चलती है, सोसाइटी में क्या क्या रूल्स होने चाहिए, उसका हम ट्रेनिंग कर रहे हैं। काफ़ी लोगों का इशू क्या होती है कि पता नहीं होता है कि सोसाइटी के जो भी मेंबर्स हैं, खास करके लेट्स सो सीएसटी के क्या पावर्स हैं, क्या रूल्स हैं, कैसे वो मैनेज करना चाहिए सोसाइटी। एंड सेकेंडली रेसिडेंट पॉइंट ऑफ व्यू से, रेसिडेंट पॉइंट को अगर कुछ रेज करने हैं, कुछ कंसर्न्स, सो क्या नॉर्मल वे है, क्या लीगल्स वे है, राइट। कि अगर आपका बात नहीं मान रहा है, फिर भी अगर हमको कुछ कन्वे करवाना है, तो फर्स्ट ऑफ ऑल वी विल गो विद द, लेट्स से हमने ईमेल डाला या हमने लेटर डाला, उसके बाद भी अगर कुछ नहीं हो रही है, सो व्हाट विल बी द नेक्स्ट प्रोसेस, हम उसको कैसे मैनेज कर सकते हैं। तो ये सारे का हमारा डिस्कशंस होगा। एंड अपार्ट फ्रॉम दैट, अगर
Maharashtra Societies Welfare Association as well as Sarkar Bharti, I welcome you all to this session on cooperative training in the Maharashtra Cooperative Societies Act, and then we'll go into the management of cooperative societies. Right? If you have got questions, you are pleased to ask, or if you can take them down as they have already said. What we'll do is we can then discuss it at the end of the session, or you can ask me, stop me and ask me in between. I'll be able to answer your question. Now this 97th Constitutional Amendment, can I speak without the mic? Can you hear? 97th Constitutional Amendment. This is a very epic amendment which happened in one state to another. Certain provisions, main provisions, will be common throughout the entire country. Correct? Just like you had GST, one country, one tax. The same way they felt that there was a need to harmonize this Cooperative Societies Act. Therefore, they came out with this 97th Constitutional Amendment. If anybody has got slight knowledge about the Constitution, I'll just give you an idea what a Constitution is. It's basically Bharat ka Samvidhan, the entire literature about the country and the method of functioning is given in the Constitution. Now the Constitution is just like any other textbook. Correct? In a textbook, various items are divided into various parts, and each part is called a chapter. In the Constitution, instead of calling them chapter, they call them part. So you got part 1, part 2, part 3, like chapter 1, chapter 2, chapter 3. The Constitution you've got part 1, part 2, part 3 and so on. So like this you've got 22 parts in the Constitution, 22 chapters in the Constitution. Right? You've got 12 schedules, 4 appendixes. The Constitution has been amended in India as on last year, 205 times it has been amended. This is the 97th Constitutional Amendment, more into cooperative societies. Now if you see the first chapter of the Constitution talks about India and its territories. Correct? The second chapter talks about citizenship. Part 2 talks about citizenship. Part 3 in the Constitution, need the previous slide. Previous slide. Part 3, chapter 3 in the Constitution talks about fundamental right. Correct? Talks about fundamental right. In this fundamental right, there is an article, Article 19(1)(a). 19(1)(a) article talks about fundamental right of freedom of speech or expression. In India, any person, it is the only country in the entire world where they have got so much freedom of speech. Any person can talk anything, nobody is there to object, nobody can take any action. Correct? But he has to limit his speech to such a manner it does not hurt the sentiment of the third person. So first fundamental right is freedom of speech and expression, 19(1)(a). Yeah.
So hope all are comfortable in English, right? Otherwise, अगर हिंदी में रहेगा तो सर से हम रिक्वेस्ट करेंगे.
Yeah, what I will do is whenever we come across MCA management, na, so I'll make a combination of Hindi and English. So first fundamental right, freedom of speech and expression. Second fundamental right, assembly of 2 or more persons in a place without the use of arms. Correct? If you have arms and ammunition, you have to take permission of the police. You cannot assemble. But if you want to assemble quietly, you do not take anybody's permission, correct? Assembly of two or more persons in a place without the use of arms, fundamental right. The third fundamental right was formation of a union or association. So 97 Constitutional Amendment, they brought about an amendment in this third fundamental right, 19(1)(c), where they inserted a word, cooperative society. So they said fundamental right to form a union, association or cooperative society. So after the 97 Constitutional Amendment, formation of cooperative society, Janma Siddha Adhikar. It become a fundamental right. Any person in the country who wishes to form a cooperative society, he can go ahead and form a cooperative society. Nobody in the country can object to such a person forming a society because it has become a fundamental right. Now, having said it has become a Janma Siddha Adhikar, the government said, whom should we give this power? Because cooperative society is a state subject. So they then came out to the third amendment, second amendment, part 4, chapter 4 of the Constitution. Chapter 4 of the Constitution talks about directives of state, all things related to state. In chapter 4, they introduced Article 43B. Correct? They said, formation of a cooperative society will lie with the respective state government. So every state government should encourage formation of cooperative societies. So first amendment was formation of union, association of cooperative society, fundamental right. Second amendment was this formation is entrusted to the respective state government. Every state government should encourage formation of cooperative societies. Third amendment, they inserted a new chapter, 9B. Chapter 9 talks about municipalities, 9A talks about panchayat, 9B talks about cooperative societies. So they introduced this new chapter, 9B, where they brought 243ZH to 243ZD, 13 new sections. This is the chapter where they said that the certain provision should be common throughout the entire country because of the state subject. Next. Now, which are those provisions? I just given some of the provisions here. First is number and term of members of the board and office bearers. Term should be 5 years. Correct? They said the number of members in a cooperative society, correct? Whether it be a cooperative housing society or a cooperative bank, cooperative credit society, they said members of the managing committee maximum they restricted to 21. What is the reason for doing this? If you have heard about cooperative banks, there are so many cooperative banks in our country. In Maharashtra alone, you've got at least 21 or 30 cooperative banks. Now, all these cooperative banks, you had a number of directors. Correct? They had, say, 30, 40 directors in the board. Right? So, more the number of people, more the crowd, more the mess. Correct? So, there used to always there used to be a lot of discussion, hot thing going on, discussion. Nothing used to come into implementation. So, the government said, let's bring an end to all this. They restricted, they said, maximum number of members in a board in any cooperative society, they restricted it to 21. So they amended, when you do about MCS Act, I'll tell you that, where they amended the respective section and they said maximum number of members should be 21. Term of members of the managing committee. Every election, like a Lok Sabha election, they said there has to be an election in a cooperative society. There has to be mandatory provision. You have to have election in a cooperative society. And that election, they said it has to be done through an authority called State Cooperative Election Authority, SCEA. In Maharashtra, the State Cooperative Election Authority is nothing but your Deputy Registrar. The Deputy Registrar of the State Cooperative Election Authority. So you have to get elected only through State Cooperative Election Authority, depending upon the strength of the society, where it is less than 250 or if it is more than 250, you have to get an election done through State Cooperative Election Authority. Suppression and suspension of board interim management, we'll discuss this later. Audit of accounts of cooperative societies only through empaneled auditors. If you see in Maharashtra, in Thane and Mumbai alone, in Thane alone, we have got nearly 3 lakh cooperative housing societies. Okay? I'm just talking about housing societies. We have got nearly 3 lakh cooperative housing societies in Thane alone. If you thinking of the number of types of societies, there are 53 types of societies. You've got a cooperative bank, a cooperative credit society, salary earner society, sugar cooperative societies, textile cooperative societies, so many types. You've got various types of societies. You've got 53 types. Housing society is only one of them. In housing society itself, you've got nearly 3 lakh housing societies in Thane alone. What they found out was, when they did all this exercise, they found that nearly 80% of these cooperative societies, they did not get their accounts audited. For years together, right from the time the society was formed till 2014, nobody even bothered to get their accounts audited. Okay? So the government said, we have to bring an end to this. It is mandatory provision that the audit has to be done. Therefore what they do, they introduced a new clause here, audit and accounts of cooperative societies only through empaneled auditors. They said it has to be done only through empaneled auditors, and audit is mandatory every year, compulsory to be done. Next is governing and general body meetings. Convening general body meeting. General body meetings earlier, if you have noticed, the earlier section was, it has to be held on or before 14th of August. The earlier bylaw prior to 2014. After the amendment, they said audit AGM has to be held on or before 30th September, mandatory. Right of member to get information, we'll discuss this also in detail. Filing of returns. We are not talking here about income tax returns. We are talking about returns which a society has to file with the registrar. Correct? They made certain returns compulsorily with the registrar, and they said these returns have to be filed on or before 30th September. Offences and penalties. First time in history of cooperative societies, you have got this penalty section. Previously, any person could do anything in a cooperative housing society. They will escape with a fine of 100 rupees. Nothing else. Correct? Escape with a fine of 100 rupees. First time in history, they came about these offences and penalties where the government itself prescribed, if these are the offences, these are the penalties. And the offences and penalties, the penalties could used to go to up to rigorous imprisonment of 2 years also. Correct? I have got a separate slide where we will discuss about these offences and penalties. Now, not only these amendments, the 97 constitutional amendment then put a Ramban. They said, every cooperative society, every state government should amend its Cooperative Societies Act and bring it and align it with the 97 constitutional amendment. And for this purpose, they said, we will give you 1 year's time. 1 year's time to amend your respective Cooperative Societies Act. If you do not amend your respective Cooperative Societies Act in 1 year, whatever is stated in the 97 constitutional amendment, that will prevail. Correct? So every state government started amending. Maharashtra also started amending its Cooperative Societies Act. So they amended their Maharashtra Cooperative Societies Act, got amended with effect from 14th of February 2014. The new act came into picture, which was called the MCS Act of 2014. Next slide. Yes. Now, I told you cooperative society is a state subject. Your cooperative societies, if you see the act, this is the size of the act and the rules together. Correct? Now, the act is so large. In addition to the act, you've got set of rules. There are 53 types of cooperative societies. Housing society is the only society which is non-profit making. Please understand. Housing society is the only society which is non-profit making. All other societies which are there were profit making societies. Housing societies was non-profit making society. Therefore, a representation was given to the government which said, why do you include housing societies in the act? The act is so large. We have to see the entire act in order to understand any provision relating to housing societies. Maharashtra government accepted the view, accepted the representation. Then they found a committee of which Ramesh Prabhu, Shilpa Shingare, myself, and there were 3-4 people. We also were members or assistant members in that committee, and we recommended to the government saying that don't change the act, bring a new chapter only for housing societies. So there was a committee which was formed, there are a number of IAS officers. So they said that what you do is, you all tell us what are the changes you want to bring in that particular chapter, what are the provisions you want to include in the chapter. We will then deliberate separately, and then we will enact this new chapter. And that's how 9th March 2019, Maharashtra government passed an ordinance 9 of 2019 where they introduced a new chapter only for cooperative housing societies in the Maharashtra Cooperative Societies Act. So now when you have to refer anything related to housing societies, you need not go through the entire act. Directly go to chapter 13B. In chapter 13B, every provision relating to housing societies is given in one single chapter. Correct? This is a very good amendment, very good move of the Maharashtra government, as a result of which this has solved a lot of issues among all member societies, and they have all applauded this amendment which has come on 9th of March 2019. Remember, this amendment has come with effect from 9th of March. So 9th of March 2019, the Cooperative Societies Act, so far as housing societies is concerned, is governed under chapter 13B. Now there are a set of rules also which had to follow, set of bylaws also which had to follow. But these rules and bylaws, one, because of COVID, they could not be produced. Now they were saying that they would be produced in December 22, but December 22 is also gone, it has not yet come. We hope at least before December 23, the new set of rules, new set of bylaws will come, which will be adopted and be common for all types of societies. Yes. Any questions so far here? We will then move to management. This is the most important part of the entire discussion or the entire training for today. What I will do is I will make this as interactive as possible. You ask questions, I will give you answers. You don't answer, I will answer. Right? There are some senior members also. I can take knowledge from some members. But what we'll do is we'll make this as interactive, otherwise it will become too boring for you. Correct? I am used to giving lectures for 4 hours, 5 hours together. So you might get bored. For me it will not be. I'll just keep doing the talking, you will have to do the nodding. Yes. 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 How many of you are familiar with Cooperative Societies Act? Familiar. I'm just saying familiar. They have defined now what a housing society is. Housing society, according to the definition, is the object is to provide with members open plots for housing, dwelling units or flats. Simple. So definition very simple, very clear. The object of an housing society is provide what? Members with what? Flats. Just like you have got a flat in your building. I'll just give you an example. Then you will have to tell me under which type your housing, your society falls. Correct? I'll give you an example. The first type of housing society, tenant ownership. First type of housing society is tenant ownership. In a tenant ownership housing society, what happens is 10 members join hands together. Correct? 10 members, 10 persons join hands together, 10 individuals join hands together, and they form a society. Correct? So they join hands and form a cooperative housing society. Right? Understand? So first what they do, they join hands together and form a cooperative housing society. After they form a cooperative housing society, 10 members, these 10 members then find out a piece of land. Correct? They find out a piece of land, and they, to their luck, they find out they have got 10,000 square feet of land, or say 12,000 square feet of land. What they do is, the society buys this land. That means these 10 members contribute 1 lakh rupees each. Cost of the land is 10 lakhs of rupees. Each of them contribute 1 lakh rupees, and the society then pays money, buys the land. So when the society pays money and buys the land is in the name of the society. Correct? Why? Society is paying for it. Society is doing an agreement towards purchase. So the land is in the name of the society. Then these 10 people again join hands and said, we have purchased the land, each one of us to be allotted 1,000 square feet. 2,000 square feet will be the common area, our roads and things like that. And we will have to construct bungalows for each one of us. So these 10 people then again contribute. The cost of construction, let us assume, is 5 lakhs of rupees. So if they contribute 5 into 10, 50 lakhs of rupees to the society. Society then calls a contractor and they construct 10 separate bungalows. Correct? So the land belongs to the society. Bungalows are constructed by the society and members are directly benefited out of that construction. 10 members, 10 bungalows. Does your society fall in this category?
No.
This is tenant ownership. So in a tenant ownership society, the land and the building both belong to the society. Correct? And society allots to each of these members flats or bungalows or dwelling units. Tenant ownership. Okay. Second type of society is tenant co-partnership. In a tenant co-partnership, land is there belonging to a landowner. There is a builder who comes and tells the landowner, you have got this area of land, 1 acre of land. You do not have the money and expertise to develop it, make potential use of the land. I will do it for you. So the landowner says, "Isme mera kya fayda?" So he says, okay, what we'll do, we'll enter into a joint development agreement, or I will buy the entire land from you. Correct? I will buy the land from you, or we'll enter into a joint development agreement. And in the joint development agreement, he specifies, when I complete this construction of the entire building of say 20 floors, I will give you 3 flats plus 50 lakhs in cash. Correct? This is the agreement. Right? So the land belongs to the landowner. Builder, developer constructs the building. He sells the flats in the building to prospective individuals. Then he forms a society, maintains the society for 2 years, then hands over that society to the members. This is tenant co-partnership. Which category you fall? Ownership or co-partnership? Second. So you come under the second category, tenant co-partnership. So in a tenant co-partnership, the builder might be either the owner of the land or he might have entered into a joint development agreement. Right? So understand very clearly. In tenant ownership, the land and building belong to the society. No further conveyance has to be done. Whereas in a tenant co-partnership, land is the name of the landowner, building is constructed, builder, developer. Who is the member? Individuals are members. Correct? 3 different parties, nobody having total control of the entire property. Land belonging to landowner, building belonging to the builder. Members are just flat purchasers. Correct? Therefore, they introduce a clause in the object clause 5, they introduced where they said mandatory within 6 months from the date of formation, within 4 months from the date of formation of the society, you have to obtain conveyance of land and building in the name of the society. Correct? After RERA has come to picture, RERA has made it mandatory, saying that once you form a society, next minute, within 3 months, you have to obtain conveyance. Correct? RERA was very strong for the members, correct, for the flat owners. But after COVID, there was a lot of problems which builders had to face. There was a lot of losses for the builders. So they have become a bit soft, saying that, okay, you try to do conveyance as fast as possible, but hand over society, do the conveyance as fast as possible.
Excuse me.
Yeah.
So I have a question in the second classification.
Huh.
As the example that you stated, like the builder is someone different than the landowner.
Correct.
He buys it.
Only when there is a joint development agreement,
Okay.
where the landowner says, I also want to be a party in the development,
Okay.
then only he gets those flats. And
So how do we get clarified that is our property?
So what you'll have to see, you have to see an agreement. In your agreement there will be a clause which says that this particular land was situated, Lodha and so on so builders has entered into a joint development agreement. It mentioned on agreement held on so and so date, they will mention joint development agreement, and they will also attach the copy of the joint development agreement or give the. One of the cooperative principles is equality. Principles of cooperation is equality. There are 7 principles of cooperation. Among the 7 principles of cooperation, the first principle of cooperation is equality.
Superb. So how much time does it take to define or like government data or a document to provide this like equal share, equity kind of share?
Society is formed, you will be given shares, everybody is giving 10 shares. Share capital, आपका share certificate, आपका जो share certificate, your share certificate which is there, that is a document which says that every person has got equal share.
But share document we didn't got it.
It will come. Share document will come. I'll come to all that. Don't worry.
Okay, sir. So I think 2 corrections here.
Yeah.
Not corrections, but an additional point. So one is like in our case, Lodha has purchased the.
And shares are issued, then he is one member. But if it's issued 10 separate flats, then there are 10 members belonging to the same group.
Single person. Yeah.
Okay, so that's how like majority also they can accumulate.
Correct?
Individual flat wise share being issued.
Yeah, individual fair.
Yes.
So in that case, I mean, he will get 10 shares.
He will
And
get
hence he has little bit of more priority compared.
So that is the reason
So, but
every society member.
I think you are telling we have Lodha has bought the land, it is not because
Yeah, it
lands
is
have
not
been given.
relevant for
na?
us.
I know. I have.
Sir, there could be one second.
I bought
I'll
the
also
land,
add
I can
something to
say,
what he
I
says.
will give you this much of cash and this much of
Flat, yes. He can break the consideration. That consideration is depending upon what he says. Na? He can say that I will consideration of say 50 lakhs, 20 lakhs I'll give you cash, 30 lakhs I'll give you 2 flats here in the society. That also he can say. Because finally it is how Lodha deals with it. Third type of other housing society, basically this is nothing but premises cooperative societies, commercial offices, basically. Third type of housing society. Interestingly, this is covered under as a housing society. Please understand. This is covered under housing society, even though it is a premises cooperative society, which is nothing but offices or commercial units. But then they have been classified as a housing society in this chapter. Yes. Now we'll go to the next portion as general body. What is a general body? Can you say what is general body is? You had a general body meeting now? Yes, you had some special general body meeting. So what is general body? What is general body? General body is nothing but members of the society. All members of the society. So if your society has got 1,200 members, all that 1,200 members will constitute the general body. Correct?
So it's like owner of the flat.
Owners of the flat, yes. Now, why I have said this is because there is a section 72. Section 72 of Maharashtra Cooperative Societies Act, bylaw number 110, clearly defines final authority. In a corporate society, corporate housing society, who is the final authority? Final authority in cooperative housing society is not secretary, is not chairman, is not treasurer, it is not managing committee, it is general body. General body in a cooperative housing society is the final authority. Management of a cooperative housing society is entrusted to a set of group of people which is called managing committee. Correct? So management of a cooperative society is entrusted to a group of people called managing committee who are duly elected under section 73 CB of the Maharashtra Cooperative Societies Act, which is through SCCA. We'll discuss about this later. Right? So final authority in a cooperative housing society is who? General body. And what is general body? Members of the society. So now you have to understand what is the definition of member. Understand what is the definition of member. Yes. According to you, what is member's definition? Owner of the flat. Yes, but that does not come in the definition. Next slide changes to it.
To whom share certificates are released? To whom share certificates are released? Kind of that, is it? Like equity holders.
The first answer which you gave was more appropriate than the second answer. You will see why first answer is more appropriate. I'll explain also. So a member of the society Section 154B 17 defines a member is a person, 18 defines member as person joining in an application for registration of a society or formation of a society. Person joining in an application for registration of society or formation of society, or a person who is admitted to the benefits of membership of society after society is registered. Correct? So they are talking about two types of members. Members before society registration or who have helped in society registration, and members who have joined after society is registered. Correct? When you took or paid the last check to the builder, correct? When you took the possession of your flat, you would have given a final check. There you would have given 24 months maintenance charges, correct? Charges for formation of society, 500 rupees towards share capital, 100 rupees towards entrance fee. All this you would have given as a final check, correct? And then you would have also signed one green color form, correct? That is the form for application for membership for the society. At that point of time, you wouldn't have known, you would have just signed because you wanted to take possession, correct? Sentiment value is the flat. That paper has no sentiment. Now that paper has got value, correct? So you sign that application for membership, and you also sign a form called Appendix A, a green color form, where your name is there and the end there you sign. If you are a single owner, you sign singly. If you are a joint owner, both the joint owners will sign. That is called Statement A. Now this document is used for formation of the society. So if a member is defined, person after registration of society is a member. Correct? So there is no difference between promoter member and member which is formed after registration. They are all classified as member. Correct? All classified as member. And the section further says member includes associate, joint, provisional. Now understand, I'll explain this associate, joint and provisional. It was never defined in the Act earlier. First time joint and provisional member has been defined. Earlier year we had only definition of associate member. Now they have defined associate, joint and provisional member and included this in the definition of members. Correct? Now understand. I told you Maharashtra Cooperative Societies Act was amended in 2014. MCS Act got amended in 2014 after the 97 Constitutional Amendment. Prior to 2014, what the Act was? 2014, what the Act is, correct? And 2019, the new chapter, new Act has come, Chapter 13B, correct? I will define associate members in all the three chapters, correct? In all the three Acts, and you will understand what the difference and how the government changed this for the purpose of members. Please understand. So prior to 2014, associate member they said was person joining an application for registration of the society and who has got right title interest in the land and building of the society, right? So prior to 2014, that right title interest in land and building was not there. That means prior to 2014, if I am a member of the society, prior to 2014, I could make any person as an associate member. So if I wanted to make Nidhi as an associate member, I have to tell Nidhi, please sign this form. I'll prepare a form, sign that, pay 100 rupees to the society and say, yes, Nidhi is the associate member. Now why do I make an associate member? Because I am not in a position to participate effectively in the working of the society. Correct? I am not in a position, I keep on traveling always. I am never in India or keep on traveling. So I don't know what is happening in the society. So what I do, I say, yes, Nidhi, you are there always in India, always here. I will make you an associate member. You attend all meetings on my behalf. So prior to 2014, the Act was like this. But what the people used to do is, they used to take advantage of the situation. Once you make him an associate member, they used to take advantage. And so some members used it to their convenience. If they wanted to bully the society, they used to make an advocate associate member. So in every meeting, the advocate used to come and sit. Every meeting used to create a ruckus. Correct? So the government got a lot of representations from society saying that you have defined associate member as such a person, any person can become an associate member. This is wrong. Please make a change here. Government took note of it. 2014 when the Act got amended, they changed the definition and they said associate person has to have a right title interest in property of society. That means if you have to make a person as an associate member, he should be owner of the flat.
Super, right.
Correct? Again members went to the government and said, this is rubbish. My society was formed in 1985. My father is today 80 years old. He is not able to participate in the affairs of the society. You have now said to become an associate member, you should have right title. When he purchased the flat, he was the only earning member. My mother was a housewife. I was a child at that point of time. Now you are saying to be an associate member, I have to have right title interest. That means you mean to say my father has to sell a portion of that piece of flat in my name so that I can become an associate member. Government said yes, point well taken. They said yes, we will do an amendment. Therefore in 2019, when they brought this new chapter, they amended this definition of associate member. And they said, associate member is a person who is either husband, wife, father, mother, brother, sister, son, daughter, son-in-law, daughter-in-law, nephew, niece. So they defined 12 persons. They said, only these 12 types of relatives could be covered as associate member. So 2014 Act removed totally any person to be an associate member, they removed. 2014 Act, they said person having ownership, that also they removed. They said now you can make any person as an associate member, but he should be of these relatives. Who? Husband, wife, father, mother, brother, sister, son, daughter, son-in-law, daughter-in-law, nephew, niece. Correct? So they have changed the definition of associate member and they said only these relatives could be made associate members. Only these relatives could be made associate members. Now why is he to be made an associate member? To exercise his rights. Whose rights? The rights of the owner. Why to exercise his rights? Because owner is not there in India. Most of the time he is traveling. He is not in a position to attend meetings. Therefore the owner says, since I am not there in India, he recommends to the society, make my son or daughter or of these one of the 12 relatives as an associate member. Clear? So now the act is, if you have to appoint an associate member, he should be in the definition of these 12 relatives. Correct? Okay. I explain.
Okay, so before that, so I think whatever you discussed regarding this 12 members or 12 relations, so that is like the policy to the society, and because of XYZ reason, if
I am talking about member. I am not talking about managing committee. I am talking about member. Member can appoint a person as an associate member, and that person who has to be an associate member is this, any one of these 12.
So that has to be documented, right?
Yes, there will be
Cannot
a.
verbal right.
No, there is a document. You have to sign one appendix. Appendix 4. You have to sign. You have to give 100 rupees to the society. Society will place your application in the managing committee meeting, and they will approve your application. Once your application is approved, that person will become an associate member. Now, question is whether this associate member can attend a meeting of the society. Answer is yes. Correct? Answer is yes. Correct? Second,
Sir,
will the name of this, one second, will the name of this associate member be in the share certificate? Answer is no. Why no? You all said no. Why no?
But he is not the owner.
Exactly. He is not owner. Please understand. Only owner's name will appear in the share certificate. Associate member, he is just been recommended by the original member. Correct? To exercise his rights.
Like power of attorney.
Correct? In this society. Correct? So his name will not appear in the share certificate. So can he attend meetings? Yes. Can he be elected? Answer is yes. Can he be elected in managing committee? Answer is yes. But written NOC from original member. Now understand. Suppose I make my son as an associate member. Yes? Understand? I make my son as an associate member. I have not given him right for becoming managing committee member. Correct? I have just given him right of associate membership. So when there is a meeting, if I am present and my son is also present, only I can attend. Son cannot attend. But if I am not in a position to attend, then I have to give a letter to the society saying that please allow my son, who is an associate member, to attend the meeting.
That is one time or every time?
Each time the son wants to attend the meeting, he has to take an NOC of the original member. Otherwise, he cannot attend the meeting. Because he is just an associate. He is exercising his rights when I am not there. So when I am there, I will attend. If I am not in a position to attend, I have to give an application to my son and tell my son, take this letter, go to the society, attend the meeting. Correct? Understood? Now, when I sign NOC for my son to take part in the activities of the society, take part in the election of the society, then I lose my right for election. Then in that case, I can neither attend the meeting nor get elected in the meeting. Please understand. So once I give an NOC to the associate member to stand for elections to the managing committee and he gets elected, I lose my right. I will not be able to attend any meeting. All my meetings of the society will be attended by my son. Clear? Understood? But my name of the son will not appear in the share certificate. Why? As he said very clearly, he is not the owner of property. Clear? Let's go to the next. Joint member. Again, if you see 2014 Act bylaws, now the bylaws at present which is there, if you see, everywhere in the bylaws it talks about I. Whereas, person would have purchased a flat, he always purchases flat, husband, wife, both together purchase the flat. It is a we, joint flats. But all your application for membership says I. No application of membership says we. So first time they introduced this concept of joint members. What they said, person joining an application registered for society jointly, correct? So they made only a single change. So who is a joint member? Person joining an application for registration of society jointly, which is subsequently registered, or a person who is admitted to membership of society jointly after registration. Correct? That means, joint member means Mr. and Mrs. A have purchased a flat in an agreement for sale from the builder. Mr. A's names appears first, Mrs. A's names appear second. So Mr. A and Mrs. A are known as joint owners. They are known as joint owners. Understand? They are joint owners. Both their names will appear in the share certificate. Agreed? Yes? Both their names will appear. Why? Both are owners. So both their names will appear in the share certificate. Right? But Mr. A's name will appear first. Mrs. A's will appear next, second. Right? Who can attend meeting? One of them, not both. Only one of them can attend. Who can attend? If Mr. A's name is written first, Mr. A has got the right to attend the meeting first. In his absence, Mrs. A. In absence of Mrs. A, if Master A is also a part of the agreement, Master A. In absence of Master A, Miss A, if he is also a part of the agreement. Correct? So in case of joint membership,
I guess NOC will be not required if Mr. and Mrs. A swaps joining the meeting, but in case of their son or daughter wants to join, then NOC from them is required. Is it so?
If Mr. and Mrs. A are joint owners, Master A and Miss A cannot come and attend a meeting even with a proxy or letter of authority. No. In a housing society, no proxy or letter of authority holder is allowed to attend meeting. So, Mr. A and Mrs. A only have a right to attend. Master A and Miss A, if they are not part of the agreement, they do not have a right to attend the meeting.
But as per that thing, like 12 family members,
That is associate members.
so associate members rule doesn't work with this joint.
Yes, go again. These joint members can also, as he says, these joint members can also appoint associate members.
So that is
These
what I'm
joint
saying.
members can also appoint son and daughter as an associate member.
That is what I was
Form an
saying.
obligation.
Yeah.
Correct? If that is the case, then yes, they can attend. Correct? But again, in absence of the original member.
Apart from the blood relations, joint can be anyone, right? Two friends, example.
It all depends upon,
which is not
so long you have a good connection between both
Yeah.
of you all and the friends,
But
one does not dupe the other, you can go ahead and make an agreement.
During purchase time, whoever there in
Any
as a
person
joint-
who is there in the agreement, they can.
But in that case, if the joint is having some, apart from the blood relation or the legal hair, if they want to appoint their son and their daughter to
As
attend
associate.
the ceremony,
As
associate.
Yes, they can do.
They
If
can.
the joint member can appoint any person as associate, provided they are in that 12th category of
Blood relationship or legal hair.
Yes. Clear? Associate member, joint member, clear? Any question here?
Maybe one question.
Yes.
So in case of associate, it will require the NOC to join it. In case of joint, maybe the family and secretary, it will not require any NOC.
You don't require NSC, but if
Either
Mr.
one can join.
Yes, if Mr. A, first Mr. A, if he is not there, Mrs. A. If Mrs. A is not there, whoever's name is there in the agreement, they can attend. But all four, all two, or all four, or all three cannot attend.
only one.
Many societies ask me this question.
So flat
Yes.
rule is one
Remember,
person,
it
one
is-
representative from one owner.
Membership, even though definition talks about joint, attending meeting is only singular. You cannot come with the entire package. Correct? You have to be singular. Only one person is allowed to attend because voting in a society is by the person personally, and one vote, one member.
But in general body meeting, don't they attend? No, only one.
I am talking about general body only. Managing committee mein, if he is a managing committee member, then naturally necessary cannot come.
And when there is an election, only the owner can elect, right?
Owner can elect.
Owner can give the voting. When there is an
Third
election.
flat per vote.
Maybe member,
Vote
say
is
member.
one, right?
One
One per flat.
per flat.
Sir,
Yes.
I wanted to understand the definition of nephew and niece because in India, everyone ऐसे कि दूर का मामा, दूर का काका, इसका ये, इसका वो. How do you define?
I started with saying husband, wife. Correct? So I, my wife. So my nephew, my niece, or my wife's nephew, my wife's niece.
Okay.
Clear?
Yeah.
Yes. It cannot be my brother's nephew or my sister-in-law's nephew. Not possible. So I started saying husband, wife, father, mother. My father, my mother. Husband, my wife. My son, my daughter. My son-in-law, my daughter-in-law. My nephew, my niece. Got this? Yes. Provisional. Again, when a member dies, correct? When a member dies, the society has to have some person who it can deal with on account of death of the member. Correct? Therefore, they introduced this concept of nomination. We'll discuss this also in detail. Very interesting. You should understand nomination. Every person here who's the owner of a flat has to do nomination, mandatory. Correct? For that, you should understand nomination. So, what they decide, provisional member? Provisional member is a person who's admitted to the benefits of membership of a society temporarily on death of the original member temporarily on death of the original member by way of nomination. By way of nomination. Correct? So if Mr. A is a member of the society and he has nominated Mrs. A, he has nominated Mrs. A through a nomination process, and Mr. A dies, then Mrs. A will become member of the society. Mrs. A will become member of the society. So what will she get? She'll get membership rights. Please understand. She'll get what? Membership rights. She will not get ownership rights. We'll discuss this in detail.
Sir,
Yes.
can I come up with one scenario here? Consider this is debt that you come up with. Consider there is a sale deed, and sale deed to someone who is outside that 12 relations bracket. Okay, some proper sale deed. Mr. A was the proper owner. Okay, he had not given any NOCs for attending any meetings. He was only attending, but he had, due to some reason or down the course of line, timeline, he had sold it to Mr. Z, who is none of his 12 relatives.
Correct, he need not be, no?
So in between that sale thing happens, some 2-3 months it might take time. So if any SGM or AGM, GM happens, general body meet happens, then who will be able to join that?
Understand? Once the property is sold,
Yeah.
please understand, once the property is sold, the documents of sale along with transfer documents have to be given to the society. Correct? And you have to pay 100 rupees plus 500 rupees plus 25,000 rupees as transfer premium to the society. Society will place it in its managing committee meeting. Then Mr. Z will become a member. But if that agreement is only signed, transfer documents are not given to the society, correct? And Mr. A, as you say, dies, correct? In that case, Z cannot attend the meeting because he is not yet a member. He can attend meeting only if he is a member. He cannot attend meeting if he is not a member.
So what is that document name, sir, you said?
Transfer set. There's a transfer set of documents which you have to select. We've got it in the slide.
So the society CHSL has to maintain a list of or track of transfer certificate in case any.
Yes, everything. I'll explain. All that will explain. Yes. Clear? Any questions about this?
One thing.
Yes.
So, when you said about nominee, so
We'll discuss in detail. I'll discuss.
okay.
Correct. You'll have a lot of questions on nomination. I'll discuss. Yes. Next slide. Yes, we discussed this. Who is a final authority? Yes. Next, general body we discussed. So general body, yes, definition. Next, general body meeting also we have discussed. Next. Yes. I have discussed what is associate member, joint member, provisional member, person. Now understand. Who can be members of a society? Understand?
What is person?
Who can be members of a society? Any individual can be a member of a society. Correct? Who can be member? Member means individual, firm, Hindu undivided family, company, association of persons, body of individuals, local authority, state government, central government, cooperative society, any of these categories defined under definition of person. It's also given here eligibility. All these persons can be members of society. In case of an individual, please understand, individual can be a member of the society only if he is a major and he is not an insane person, he is not a mad person. Correct? That means the law says who can enter into a contract? Only persons who can enter into a contract. A minor cannot enter into a contract. A mad person cannot enter into a contract. Contract Act 1872 very clearly says persons who can enter into a contract are persons other than a minor or a person of unsound mind. Leaving these two people, any person who is a major, whether it's a boy or girl or father or mother, can enter into a contract. They all can become members of society. So individual who is competent to contract under the Contract Act, competent to contract is other than a minor or a person of unsound mind. Central government, state government, Hindu undivided family, HUF, company, firm, local authority, AOP, BOI, cooperative society, public trust, and legal body, any other entity as notified by the central government. All these persons can be members of society. Please understand. Now in your membership, you will have only individuals. You can have a person who can be a company as be a member. Please understand. Correct? There can be a person, so a company would have purchased some flat. Correct? It would have purchased a flat in a society, or it would have purchased a flat from the builder. Now that company can also become a member. A partnership firm would have purchased a flat. The partnership firm can also become a member. It is not restricted only to individuals. Correct? All these persons are eligible to become members of society. Correct? Yes. Next, eligibility.
Sir, can a non-Indian citizen?
Non-Indian citizen?
Not possible, no? So,
yes. Next. Membership. Eligibility we have done. Conditions of membership. Now, in order to become member of the society, I said first you have to sign one application form. Correct? You have to sign one application form. You have to purchase 10 shares of 50 rupees each. That means you have to purchase shares worth rupees 500 in the society. You have to give a copy of your registered document. Registered document. Remember, you can be a member of a society only through a registered document. Stamped and registered document. That means you have to buy, when you buy the flat from the builder or you also buy a resale flat, it has to be a stamped and registered document. Then only you can apply for membership. Plus you will have to give certain documents like whether you have got sufficient source of income so that you can pay to the society dues. If you do not have sufficient source of income, then you have to specify on whom you are dependent and whether that dependent person has got sufficient money to pay the dues of the society. Please understand. One of the conditions of membership is you cannot say after becoming a member of the society, मेरे पास पैसा नहीं है society का charge भरने के लिए. Because you are giving an application, a document which says I have got sufficient income to pay the dues of the society. Right? So this is one of the conditions of membership. Please understand. One of the conditions of membership which you are signing and giving to the society. I told you, at the time of taking the key to your flat from the builder, all these documents you already signed, knowingly or unknowingly. You have signed all these documents. All these documents are now there with the society record. Based on that, you have been admitted as a member. In case of a firm company, in addition to the above documents, certified copy of resolution. So a company cannot attend. Either the director can attend or any person authorized by the board can attend the meeting. Correct? The shares will be issued to the company. But for attending meeting, either the director can attend the meeting or any person authorized by the director. Next. Any questions here? Yes. Yes. Now we'll go to this. We said we are talking about member. We discuss about membership. We said the final authority in a corporate housing society is general body. And when I say general body, we talk about general body meeting. Correct? There are three types of general body meetings so far as society is concerned, housing society is concerned. First is constituted general body meeting, annual general body meeting, special general body meeting. Constituted general body meeting, annual general body meeting and special general body meeting. You understand? What is constituted general body meeting? Just understand. Don't have to copy anything, just understand. Constituted general. Now, the constituted general body meeting is a meeting which is convened by the chief promoter. When the society is formed, please understand, remember this very clearly. When society is formed, the builder or chief promoter has to hand over the society to its members within 3 months from the date of formation of society. Please understand. Within 3 months from the date of registration of society. So if your society is registered on 1st of January 2023, on or before, after 31st of March or before, on or before 31st of March 23, the builder of chief promoter has to hand over the society to the member. Mandatory provision. If the builder or chief promoter does not hand over to the society, then the builder chief promoter loses the power. Power then lies with the registrar. So whenever the builder chief promoter wants to hand over, he has to go to the registrar and tell the registrar, society was formed on this date, 1st of January. I have to hand over before 31st of March. Due to certain reasons, I could not hand over. Now I want to hand over on this date. The registrar will say, wait, when you want to hand over, he'll see his diary. Yes, I am free on this date. You can hand over on this date. So the registrar man will be present at the date when the handover takes place. Correct? So the meeting which has been convened by the builder of chief promoter or by the registrar's man, that meeting is called first constituted general body meeting. It is held only once in the lifetime of the society. First time. So you all would have had that experience, correct? 7th January, I think your handover took place. So 7th January is the date in which your constituted general body meeting was held, correct? So that was the date in which the builder or chief promoter handed over the formation of the society and all records to the society and said, from today onwards, you run the show, I will not run the show anymore. Clear? Yes. Now in the constituted general body meeting, what do you do first? In the constituted general body meeting, the first most important thing you do is, you form a provisional committee. You form what? Provisional committee. Now this provisional committee is for 1 year. This provisional committee is for 1 year. This provisional committee is equal to the main committee. No difference. Only since it is there for 1 year, it is called provisional. Correct? After 1 year, the new committee is formed by a process of election. Correct? So the first committee when it is formed is a provisional committee, is an elected body at the time when the constituted general body meeting is held. So at that time itself, the chief promoter said, how many of you all who wants to become members of the provisional committee? You would have given the names and you have said all these are now members of the provisional committee. The members of the provisional committee are there for a period of 1 year. Now another important thing we discuss in the constituted general body meeting is the builder has to give a statement of account. Now when he gives you the key. I told you, he takes 24 months maintenance. Correct? You are building a society of how many flats? 1167. So 1167 flats multiplied by 24 months maintenance, you would have got some crore of rupees from all of you all together. 18 months, correct? 18 months maintenance. So you would have given 18 months maintenance, correct? 1167 multiplied by 18 months maintenance multiplied by the amount per square feet whatever he has taken. He would give you a statement of account 7 days prior to the date of the first constituted general body meeting. He has to give the statement of account to the society. Society has to take that statement. Usually he says, he gives all the supporting documents. Society has to say, go through the supporting documents and say, okay, fine, we will get the accounts audited separately and then we will come with our comments. Till the time we will keep this statement of account with us and then we will discuss with you finally when the audit has been over of that builder's statement. Correct? Yes. So two important things takes place here. One, first important thing which takes place is a provisional committee is formed. The provisional committee is as good as the managing committee. Second, statement of account of the builder is presented. This statement of account of the builder which is presented, society takes a statement and it says that we will discuss this statement with the general body and what are the findings of the auditor as there on the builder statement of account, we will then convey it to you and then we will go for the final settlement. Now, the last most important thing the provisional committee has to do is conduct elections, hand over to the new committee. Correct? Most important thing which the society has to do, provisional committee has to do. It has to call for elections 6 months prior to the expiry of its term. So if you have taken charge on 7th of January 2023, 6th of January 24, you have to hand over reins to the newly formed committee. 6 months prior to that, say on 30th June, you have to, before 30th of June, you have to make an application to the registrar, State Corporate Election Authority and tell them, yes, we are 1167 member society. These are the names of the members. We wish that the term of the provisional committee is going to come to an end on so and so date. We wish that elections be conducted. The registrar will then appoint a returning officer. For you, returning officer is mandatory. Returning officer will now come to your society, inspect all the 1100 members list, and then he will put a timetable for election. He will say when will the election will be held. Up to that time, the old committee or the provisional committee will continue as the managing committee. Clear? Question here? Second type of general body meeting is annual general body meeting. Now, as the name itself indicates, annual general body meeting is held once in a year, annually, yearly. 97 constitutional amendment said AGM has to be held on or before 30th September. Correct? So Maharashtra Cooperative Societies Act got amended and they said, section 75 very clearly said AGM has to be held within 6 months of the close of the accounting year. Accounting year always ends on 31st of March. 6 months from the close of the accounting year is 30th of September. So your AGM has to be held on or before 30th September. Mandatory provision. Okay? So it is the duty of the society to call AGM on or before 30th September every year. So in your case, your first year will be now just 3 months. 7th January to 31st of March 23. You have to hold the first general body meeting on or before 30th September 23. On or before 30th September 23. Clear? Right. Now, what happens if you do not call an AGM? Please understand. We are a democratic country. Correct? So, democracy says, first, the reins will be given to the society to call the AGM. Society has to call the AGM. Whose society is it? Members. So society has to call the AGM. In the society, who has to call the AGM? Secretary. In absence of secretary, chairman. In absence of chairman, treasurer. If none of the three call, you have to intimate the registrar. The registrar will then call. Correct? So secretary has to call for a general body. So if the AGM is not called before 30th September and 30th September lapses, goes by, then in that case, society can never call AGM for that particular year. In that year, AGM can be called only by the registrar. Correct? So registrar will call the annual general body meeting. Correct? Registrar will call the annual general body. But when he calls the annual general body meeting, he will find out who was the person responsible to call the AGM and why did he not call the AGM. And if he finds out that the person was responsible to call the AGM did not call the AGM and he did not have valid reasons for not calling the AGM, then he will take action against such a person. And what will he do by taking action? Debar such a person from the managing committee for a period of 5 years. Correct? He will take action under section 77A of the Cooperative Societies Act. So remember, secretary in a housing society, very important. Very important person. Chairman, secretary, treasurer. Very important person in a housing society, cooperative housing society. Of that, secretary has got maximum importance. Clear? Yes. In an AGM, when we discuss about AGM, there is a set of agenda to be followed. Understand? There is a set of agenda as well. What is the agenda to be followed also is given in the Act. Please understand, what is the agenda to be followed also is given in the Act. The Act specifies, section 75 very clearly specifies what is the agenda to be discussed. You cannot write your own agenda. That you can write after the main agenda is over. Correct? So the first agenda is read and approve the minutes of the last general body meeting. So if you have got any earlier general body meeting prior to the AGM, read and approve. Second, read and approve the audited statement of accounts and also together with the report of the auditor. So you have to approve the audited statement of accounts along with the report of the auditor. Correct? Appoint auditor for the next year. You have to appoint the auditor for the next year. You have to place on record the audit rectification report. The auditor would have pointed out various defects in the functioning of the society. All these you have to bring to the notice of the members and say what is the action the managing committee is taking. You have to also place the budget for the next year. Please understand, very important, budget has to be placed in the general body meeting. Correct? Budget has to be placed in the general body meeting. Right? You also have to discuss the date and calling of elections. So in your case, you have to discuss this as an important agenda. Correct? Since your elections have to be held in Jan of 24, in your AGM agenda of 23, you have to mention that what is the date and time of the elections which are to be held. So you have to specify term of the managing committee is ending on 6th of January 24. So the elections, whatever is the date proposed by the returning officer, that you have to specify in that meeting. And last, any other matter with the permission of chairman. Correct? Any other matter with the permission of chairman. Please understand, in case of an annual general body meeting, as I said, an agenda is very clearly specified. Agenda is very clearly specified. You can discuss anything, but first you have to discuss whatever agenda has been asked or mentioned in the act. Discuss what is mentioned in the act, then you take up any other matter with the permission of the chairman, even if it is not present in your agenda. Correct? Suppose in the agenda you wanted to discuss about parking, but it is not mentioned in the agenda. A member can get up and say, we want to discuss about parking with the permission of the chairman. The chairman says, yes, we will discuss, then only you can discuss. The chairman says, no, we cannot discuss, managing committee has not yet discussed about parking, you have to keep it aside. You cannot step up and say, no, we want to discuss now, nahi to main fek dega sab kuch. Nahi kar sakta. Please understand, you cannot do dadagiri in a general body meeting. Many people have asked us, sir, can we, when members say that they want to have a particular agenda, can it be discussed or not? It's very clear. As any other matter, with the permission of chairman. If the chairman of the society says, I am not yet prepared with that particular agenda, whatever agenda is there, give it to a particular matter, in the any other matter with the permission of the chairman. So please bring your thoughts to it. And if they have gone through it and they brought their thoughts, yes, they will discuss. But if they say, no, we have not discussed about this, we will discuss it in the next meeting, you have to say, fine. They will make a mention about it in their minutes, saying that in the minutes they will make a mention. This point about agenda was discussed, any other matter with the permission of the chairman. The chairman said that this will be taken up in a separate general body meeting, special general body meeting, which will be convened at a later date.
So that has to be mentioned in the
minutes.
Minutes also that on this proposals.
Yes.
Chairman said yes and discussed. On this proposal, chairman said no, and it will be discussed in next.
Exactly.
It has to be mentioned.
Yes, it has to be minutized in your minutes.
Okay. Yes. Nice information.
If they had said and they have not documented, then what is the next course of action?
What?
If they had said in the meeting that we will discuss in next general body, whatever it may be, but they have not documented in the minutes, then
so whenever the minutes come, now that's what I am coming to. The AGM minutes have to be circulated, correct? Whether it's an AGM minutes or special general body meeting, minutes have to be circulated within 3 months from the date of holding of the meeting. So if your meeting is held on, say, 31st of January, within 3 months, on or before 30th of April, they have to circulate the minutes. Once the minutes have been circulated to the member, please understand this. Once minutes have been circulated to the member have to read to the minutes. If they find that there is anything which is not is what is discussed, as you are saying, correct? There was an item which they said, we shall discuss it later, and they have not mentioned that. You have to bring that item to the notice of the managing committee, saying that, sir, we had discussed this item, you had mentioned that we will take this item in the next general body meeting, but you have not minutized or not mentioned in your minutes. Please add the minutes. So what they will do is, they will go through the recording, general body recording, they will go through, find out whether yes, they have discussed. If they find yes, this is what is discussed, whatever you have said is right, they will then amend the minutes, place the minutes again before the managing committee, then again distribute the amended copy among the members. If a member does not come with an objection regarding the minutes which has been circulated, it is presumed whatever is circulated is final. Please understand. There is to be certain amount of responsibility from the part of you of the members also. Correct? Managing committee is elected body. It takes part of the management of the society. Correct? It's possible that they would have left out certain things which they have discussed. You as a member have to mention that, sir, this is what discussed, this was left out by you. They will amend the minutes. If they go to the recording and they find out this was discussed, they will amend and distribute the amended copy.
In case amendment copy has not been distributed by the society members, then
It is not being,
if they have not amended, after we have,
you got an authority, registrar.
So, but how to mention?
we can submit directly to minister.
Letter, anything which is to be correspondence which you have with the society has to be done either by a letter or email. No WhatsApp, no messaging. It has to be email or letter. In case of letter, hand over the letter, obtain acknowledgement. If you hand over the letter and you do not have an acknowledgement, tomorrow you go to any court of law, you will definitely lose. So whenever you give any letter to the society, always obtain stamp copy.
Is there any tag for the amendment copy of the minutes of meetings, sir?
With how many?
Is there any turnaround time is there for
3 months. 3 months. 3 months.
When the objection is raised by a member to the society,
When the society member raises an objection, he is given 15 days time to raise an objection.
Yeah.
Once 15 days time is over, and if he within that 15 days he raises an objection, it comes to the society. Society will then place it in its managing committee and then discuss this in the managing committee meeting and then amend the copy and give.
Sir, in case there is no reply back to that reminding mails that such and such points were missed in the previous minutes, so what shall one do?
You got an action which we'll discuss. You got a section called 154B8 clause 2. I'll discuss. Correct?
Okay.
All that we'll
Sure.
discuss.
Sure, we will
Correct?
do that.
AGM. Now AGM, you have to give
One
yes.
question. So, considering the provisional committee member, you mentioned like, I mean, in the AGM, we need to follow 3 major agenda, which is
3, there are 9.
Yeah. So on that, you mentioned one about the budget of the next. So for provisional committee, I think that will not be applicable.
Why it will be applicable?
It will be applicable.
Yes.
Okay.
You have to take budget. You have to take budget based
Because
on.
you are that you are it for 1 year only. Then also you are going to take the budget for next year.
So even if your term is 3 months, your term is going to end only next year. Correct? So you will have to present the budget for the next year. So what are the expenses which you are going to incur every month for the next 1 year? You have to take it. Whether it is provisional committee or main committee. Yes.
The registration of our committee was done far before the handover was given to society.
Registration of the
Committee of CHS.
registration cannot be done prior to handover. You would have discussed. There would have been an ad hoc committee.
It was like we had a handover on 1st of Jan.
Correct.
But what we saw in the document, it was written the registration of the committee was done. Committee in the sense, CHS was
Say,
done.
okay, I'll correct. What you're saying, I've got what you're saying. But what you're saying to say is, first there is an ad hoc committee which was formed. Once the registration was done to the society and the handover is done, this ad hoc committee took over the charge of the price provisional committee. That's what you're saying. Okay? The ad hoc committee will always be prior to date of handover because that's the time when they discuss. Members have to discuss among themselves who wants to become members of the managing committee, correct? Or the members of the provisional committee. Or you have to discuss in the general body itself, which is very unlikely because in a society of such a large size, to discuss who wants to become members in the general body meeting will become time consuming. So what they do is, we usually tell them, you discuss among yourselves who wants to be members of the ad hoc committee. That ad hoc committee make a letter to the builder saying that this ad hoc committee, these are the persons who have consented to become members of the provisional committee. That's what it is. Yes. Any further thing? Clear, na?
No, I think I mean, okay, I got your question. So what he mentioned earlier, let's say whenever the registration is happening, the society registration, so from that day, builder has to give the handover within 3 months. But if it is not happening within 3 months, then he has to appoint the registrar or sub-registrar in the meeting, and then they can say, builder can say, now I am going to do the handover. I think this is what happened in our case also.
Like our term would be from January to next January or in the financial year.
Yes.
Yeah.
It would not be from the time of registration.
No.
No.
So notice for an AGM. AGM has to be called within, notice for an AGM, you have to give 14 days clear notice. If it is a annual general body meeting, 14 days clear notice. If special general body meeting, 5 days clear notice. Correct? AGM 14 days, special general body meeting 5 days clear notice. Quorum for an AGM is 2/3 or 20, whichever is less. Quorum for a general body meeting, AGM or an SGM is 2/3 or 20, whichever is less. For example, the size of a society is, let us assume 1200. 2/3 of 1200 is 800. Correct? So quorum is 800 or 20, whichever is less. So quorum is here in your case 20 members. If at the appointed time 20 members are present, suppose you call the AGM at 10:30 and at 10:30 20 members are present. 20 members are present, 20 or more are present, then you can continue with your AGM. If at 10:30 20 are not present, there are only 15 present, then the chairman of the society has to adjourn the AGM. Correct? For how AGM and complete the AGM. Correct? Please understand. A member cannot complain saying that, sir, I did not attend the AGM, therefore the resolutions which are passed is not applicable to me. No. Once an AGM passes a resolution, it is applicable to all members. Why? We said general body meeting is meeting of all members. Whose interest is it to attend meeting? Members' interest. Member has to attend meeting. He has to give his views in the meeting. So if the member does not attend meeting, it is not the fault of the society. It is not the fault of the managing committee. All resolutions once passed in the general body meeting cannot be altered unless 6 months have passed. Clear? Now, in a general body meeting, when a resolution is being passed, correct? In the AGM, when a resolution is passed, there are 100 people who have attended the meeting. There is a resolution regarding parking. 50 say yes, 50 say no to parking. There is a tie. 50 members in that meeting, there are 100 members who are attending the meeting. 50 members say yes, 50 members say no. There is a tie. In this situation, the chairman has got a casting vote. Chairman has got a casting vote. He can take the resolution for the society or he can take the resolution against the society. Chairman has got a casting vote. So the chairman can say yes and say parking is applicable. Parking will become applicable. Why? Resolution in the general body is passed by simple majority. So whenever there is a tie, one additional vote is given to the chairman and the chairman has got a casting vote. Therefore, in every general body meeting, chairman has to be present. Mandatory provision. Correct? Has to be present. But if the chairman does not want to attend, or is not in town, or is incapacitated, he is sick, and he is not in a position to attend, then the general body has to attend, has to elect a chairman for the meeting from among the members present. So among the members present, they have to elect any one person as the chairman. And that chairman will preside over the meeting for that particular meeting only.
Not the members, it is not mandatory from the management committee.
Not. Members has to elect a chairman for the meeting. Members have to elect. It is not from the managing committee. Vice chairman does not become chairman.
So let us understand this with a scenario like 14 days before we have to notify everyone that AGM is going to.
Correct.
Okay. Within that 14 days, maybe consider the 7th day we found the chairperson is sick, hospitalized, will not be able to join in next 7 days also. Then, like what is the previous day notice period for assigning a new interim?
In the meeting, you have to elect a chairman.
Okay, just in the meeting it.
Yes.
Means among the 100 people who are joining, or maybe 90.
Who are present? All the persons who are present.
Sir, and one more thing. Just you had spoke that members have to elect on the agendas, do their votes for the agendas, right? If 2 persons are given vote, none of the other persons have not given the vote, whether that agenda will be valid?
Yes. Simple majority. Yes. So out of 100 people.
Out of 100 people, 2
That
members
is-
only given vote.
Let's understand. Out of 100 people, 98 abstained from voting.
Yeah.
So 2 people only wanted to vote.
No, no. 100 people are ready to vote, but they had asked for the 2 members to go to give the vote.
How is it possible? Why will 2 members vote for
Because
it?
actually, they had already done it. That's what I'm asking.
Why will 2 members ask, well, 100 members ask 2 members to vote on their behalf?
No, sir, it is not a smiley thing actually. Just I want to let you know,
Ah.
there are 2 general body meetings, 3 general body meetings, special general body meetings has happened. Service provider has came and asked that give the approver and seconder 2 names. They had noted out. Yeah, just I am not aware of this.
I got your
Smiley
point. What you want to say is, the meeting resolution is passed, correct? And after the resolution is passed, the chairman of the meeting says, give me 2 names.
No, no,
For
no.
the person proposing and the proposed person
No, resolution
second.
is not passed, sir. That is a little bit confusion. No resolution has passed. They had submitted some agenda 1, agenda 2, something is there, and they had asked for give approval and seconder name. These recordings are also there. I am not joking. If you want to say, you can see the recording also.
I refrain from commenting. I don't know what the thing is.
Yes, that is
But
happened.
the thing
In
is,
that case, what to be done?
you have to take it to the registrar. You don't have an option.
Okay.
You have to take it to the registrar.
But
If
further
you
they
find,
will ask the supporting document like recording or something which we are not having. Then what needs to be done?
you have to submit the recording of the documents which are present. Members, those who
No.
members who are present in the meeting, the registrar will come and ask the members who are present in the meeting, was this resolution passed or not? If all the members say yes, it was passed, and all members say it was not passed, this registrar will say this resolution was not passed, cancel the resolution.
And if, for suppose, example, if in front of the registrar we had objected, one person has objected one thing, is that is valid? Then what needs to be done? Because
I didn't
what
understand.
happens?
Okay, so maybe let me get right. For example, let's say if committee is presenting any agenda, for example, let's say party, and committee has presented all their views about the party, what is the issue, why it is required, not required, and so on. Right? And after that, let's say committee is asking, do we have any objections? Nobody said anything. Then what committee will say? Then give me approval and seconder name. Right? So is this the correct method of taking this forward?
What you'll have to do is, from henceforth, once you ask, nobody has objected, instead of saying everybody in favor, please raise your hands.
Correct.
So show of hands, should make it a show of hands, rather than saying anybody has got objections, take show of hands, and then you count how many voted and how many not voted. That will be better. That's a better way of doing that.
Ideal way.
Or when you say that anybody has got any objection and nobody has said anything, it is assumed that nobody has got an objection. So the resolution gets passed
No,
unanimously.
sir, many of the times, if I may clear, what happens is, I'm just adding that, like you have said, the body has taken approval and seconder has been taken, and after approval and everything, after 3 months or 4 months down the line, they don't want that particular thing. And then there is a issue of that, and then there are emails and question and answer that have been answered in spite of an approval and a second in the meetings that has happened. A certain
So
time
I'd
has
just
passed
like to
and
add
after
here,
that there are repetitive.
Yes, I'd just like to add here, as I told you, once a resolution is passed and it is not recorded or incorrectly recorded or incorrectly worded, when the draft minutes have been circulated, members have to take objection at the draft minutes stages.
Within 14 days.
Within 15 days. So once the draft minutes are circulated, you have to take objection and tell the managing committee, sir, this was not discussed, or this was inappropriately mentioned here. The wording should be different. Make a make. Managing committee will then they have to take your letter into consideration. They cannot say, no, we don't want to take this letter. So whenever there is an objection which is received from a member, it has to be taken by managing committee, presented in the managing committee meeting, discussed in the managing committee meeting, and then the managing committee has to decide. Yes, see the recording of the meeting, if whatever is said is correct, record it, or if there is a change, make the change, redistribute the minutes to the members. Once the minutes are circulated, there is no objection received, it is assumed that minutes are clear. After that, you cannot take an objection saying that, sir, we don't want that particular resolution. Once a resolution is passed in a general body meeting, it cannot be changed for the next 6 months. Mandatory.
Sir, how to understand it much clearly? Let us start from the root of the confusion. So, in an AGM or any kind of GM, some XYZ topic is discussed. So, the managing committee opens up this topic, asks, ideally it should ask for like raise up your hand or don't raise, whatever. Take a count, and then at the end, ideally they should ask this question that do you have any objection there itself, or it is not mandatory, like they can avoid this question.
Correct. So
Tell me.
if they are presented that
Because never this question was been asked, like any objection or not. Just proposal and say raise hand.
So
or
once a
not.
proposal is made,
Yeah.
please understand. Why is an AGM called? An AGM is called for discussion.
Sir, some mic.
AGM is being called for discussions. Please understand. Why is it called an annual general body meeting? Meeting of members. So that every member gives his or her view to the. Hello. Every member gives his or her views on the resolutions which are to be passed. So once a resolution is placed, member has to say, because this is a resolution placed in managing committee. Managing committee is clear as what it wants to do. Managing committee is saying, yes, I want to charge parking 100 rupees. It's clear from their side. If there is an objection which is to be raised by a member, he has to get up and raise an objection in the meeting, saying that, sir, I want to discuss on this. Why are you charging parking? Is this parking for two-wheelers, and whether it's parking for four-wheelers? In two-wheelers, whether cycle is covered, or is whether auto rickshaw is covered, whether a truck is covered, everything you have to discuss. That a member has to say. But once a resolution is passed, after that 3 months down the line, if a member comes and says, sir, we don't have an agreement to this resolution, there's no value.
Okay, so within 14 days, as you're saying, like some objection email is being done. Consider on the 13th day it was done. So what is the TAT or turnaround time for
3 months. 3 months. So once the objections are received by the managing committee will place it in the next managing committee meeting. Correct? The objection received, and they will find out what is actually been discussed. If this is not been actually discussed, or there is a change in the wording, they will intimate of you of the change. They said, yes, this was incorrectly drafted, and they will give a revised minutes to the members, revised draft minutes to the members, and that again they will give further 15 days time. Then member has to go through it and says, yes, if he is satisfied that yes, what has been now recorded is correctly recorded, he will then tell, yes, this is correctly recorded, I do not have any further objection, and no other member then comes forward with it, then the resolution or the minutes get passed.
And now coming to the previous question, like if there is no reply back to the
But not reply in company as well.
Majority of people have agreed on a particular agenda, and only 2 or 3 people they are
Objective, yeah.
So, and they are continuously they are standing on the irrespective of forums,
Once,
So,
let's be very clear. I told you, a resolution in general body gets passed by simple majority. If majority of people have agreed to a particular agenda, the resolution gets passed irrespective of whether person has objected. So if the person has objected, the resolution only you have to specify in the minutes that this resolution was put for vote, majority has passed, 2 members have objected to it, matter is closed. And the resolution is carried unanimously.
majority is also a key identifier, like
Always.
Always, the simple majority. Yes. Any more questions? AGM? Yes. Now we go to special. Now what is special general body meeting? No, the word itself, special, says special general body meeting is khas. So what is so special about special general body meeting? It can discuss only specific agenda. If a special general body agenda says we want to discuss about parking, it can discuss in the special general body meeting only parking. It cannot discuss repairs and maintenance.
The 13B template is not mandatory in SGM, right?
No. It has to give specific agenda. Correct? It has to give specific agenda. Now, who can call for a special general body meeting? Special general body meeting can be called by 5 persons. One, chairman of the society. So, chairman of the society can call a special general body meeting. As you said, there was an agenda which we want to discuss. Can we take it with the permission of the chairman? The chairman says, I am not prepared with this agenda right now. We will take it some other time. So, at that some other time, he will discuss and he will say, okay, this was one of the agenda which a member wanted to discuss. So, we will have a special general body meeting to discuss this agenda. So, chairman of the society can discuss a agenda, can call or convene a special general body meeting. Okay? Majority of managing committee members, chairman is not present, the agenda had to be discussed. So, managing committee members among themselves says, majority of them, let's call a special general body meeting. So, managing committee members, majority of them can call a special general body meeting. Third type of person who can call is members of the society. The society is not paying heed, so they will go to the registrar and tell the registrars, look, there are so many people want to call this special AGM, special general body meeting. The chairman is not ready, the managing. If the meeting is convened by the chairman and 20 quorum is not there, then adjourn for half an hour. After half an hour, you can continue with the special general body meeting. If the meeting is convened by the registrar and at the appointed time of 10:30, there is no quorum, adjourn for half an hour. After half an hour, you can continue. If the meeting is convened by majority of managing committee, at 10:30, there is no quorum, again adjourn for half an hour. After half an hour, you can continue with your AGM for your SGM. If the meeting is convened by the federation and at appointed time no quorum, adjourn for half an hour, have the meeting. Understand? So when these 4 people, chairman, majority of managing committee, registrar, federation, they convene a special general body meeting and there is no quorum at the appointed time, meeting will get adjourned for half an hour. After half an hour, irrespective whether there is quorum or not, meeting can be held. But remember, if the meeting is convened by members of the society, meeting is convened by members of the society have given a requisition, 240 people have signed a letter and told the secretary, I want you to hold a special general body meeting. Secretary has to hold a special general body meeting. He cannot say, I will not hold. If he says, I don't want to hold, you have to go to the registrar. Then registrar will convene. If 240 members have given a requisition to convene a special general body meeting, and at the appointed time, there is no quorum, 10:30, only 20 people are present. Remember, how many people signed? 240. 240 people signed for a meeting, and at 10:30, only 20 people were present. In that case, it cannot be adjourned, it has to be cancelled. Government is very clear. Where the meeting is convened by the members of the society and the members themselves are not present, don't carry forward with the special general body meeting, cancel it. Clear? Right? In case of a special general body meeting, 5 days clear notice has to be given. AGM, 14 days clear notice is to be given.
So,
yes.
One question. Quorum is less than 20 government. How many members you can? It's less than 20. 5 members.
You can have the meeting with 5. Yes, we can continue with 5. Irrespective of, after half an hour. After half an hour, we can continue irrespective whether it is quorum or not.
Provided it is not called by members.
It is a special general body, not AGM. Special general body.
So my question is, the meeting was called by the members, 240 members. How much members are required to fill up the quorum?
There is nothing. Meeting is called by 240.
Yes, sir.
Quorum required is 20. Quorum required is 20.
20 only.
20 only. 20 only. Quorum required for a special general body or AGM?
Same for all type of meetings.
20. So out of that 240, 20 present, or more than 20 is present or less than 20 present. You have to take 20 people.
Okay, so I think one related question. Let's say the meeting is called by members and it will require 240 members sign. So when we are talking about the sign, it will be a hard copy, right? So hard copy where you put the what you want to discuss and then you take it
Signatures, the flag number and the signatures.
and then you submit to secretary.
Yes, with the name and
30
signature.
days,
Yes,
within
name,
30
flag
days-
number, signature.
Okay, and within 30 days, secretary has to go for the
Yes,
SC.
not earlier than 7, not later than 30.
If let's say if 240 is not, out of 240, let's say 200 members are agreed, in that case.
Can't. Members cannot. In your case, your society at least, you need 20% signature.
But
So
on the day of-
1167 to 20%.
On the day of SGM meeting, which was announced, if those 240 are not present, like consider 239 are present, can the meeting run?
Yes. 20% should be people. 20 people should be present.
So just now you said cancel.
That is
अगर आपने अगर 240 ने मीटिंग बुलाया और आपका मेंबर्स प्रेजेंट था मीटिंग के लिए सिर्फ 15, 20 से कम, आपके लिए क्वारम कितना है? 20
सब cancel, yeah.
तो कैंसिल.
Then it is.
So I think just to clarify, इसमें बाकी में क्या है कि बाकी में आप हाफ एन आवर के लिए डिले करके आप कंटिन्यू कर सकते हो इरिस्पेक्टिव ऑफ नंबर, इधर वो 5 हो 15 हो या 50.
In that fifth category, just
Fourth category.
हाँ, फोर्थ कैटेगरी में अगर वो 20 मेंबर नहीं आता है तो वो
Correct.
पोस्टपोन नहीं होगा, वो डायरेक्टली कैंसिल.
Cancel.
दैट इज ओनली.
That is only if it is convened by members of the society.
Excuse me, sir.
First
Sir,
constituted
excuse
AGM
me.
special.
So
Yes.
the quorum is inclusive of the committee
members.
or
Yes.
exclusive?
Yes.
Committee is member, no? Yes. You had something. Clear? Anybody has question? Next.
Just one thing. So when you said those 240 members come up to the secretary, they don't come up to the secretary, they directly go to the registrar. Then
It don't come up to the.
they directly go to the registrar.
So
That means they don't write to you.
Yeah, they don't write to.
So the registrar will definitely call you and ask you why are you not convening. So you have to tell them they have not given any letter to us. Matter of what? Because the registrar will go on document.
Yeah.
Correct. What? So your document should clearly speak about everything very clearly. Yes. Yes. Next, bank account. Next one. Yeah. Election, disqualification, and no confidence person. Yeah, bank account. Bylaw number 113 says that the society should open a bank account in one or more state cooperative bank having a certificate. Correct? Having a certificate, one or more district state cooperative bank having a certificate in the last 3 years, and the bank account should be operated by jointly by the secretary along with the chairman or treasurer. Correct? So signatory to a bank account should be secretary, chairman, secretary, treasurer. Correct? Signatory to bank account be secretary, chairman, secretary or treasurer. This is what bylaw number 113 talks about bank account. Elections to a corporate society. In a corporate society, elections is done under section 73 CB of the Act. Correct? Elections to the managing committee is done under section 73 CB of the Act. Section 73 CB says the managing committee shall be elected for a period of 5 years. Correct? Managing committee shall be elected for a period of 5 years, and the society should intimate the state cooperative election authority 6 months prior to the expiry of its term. Correct? So once, suppose, I think I told you your elections are due on Jan 24. Correct? Correct? So you have to intimate 6 months prior. Suppose you don't intimate. Correct? Suppose you don't intimate. In that case, on 1st of January or 7th of January, the managing committee loses its power. So you will become a society without managing committee. You lose your power. You have to only intimate, please understand. You have to give only a letter to SCCA that our Term of the managing committee is expiring on 6th of January. Please conduct elections. E1, E2, E3 form, everything has been filled and given to the State Corporate Election Authority. They have to then act. Correct? They have to then appoint returning officer. You have to just intimate. That intimation has to go from you 6 months prior to the expiry of its term. If you do not intimate 6 months prior and the term expires, managing committee ceases to exist. Managing committee ceases to exist. Registrar will then initiate action under section 77E. And what is the action he is initiate? He will find out who is responsible for intimation. Secretary is responsible for intimation. Secretary did not intimate. Debar him for a period of 5 years. Correct? Now whenever I talk about debar him for a period of 5 years, every secretary says, "Arey acha hua yaar, jaan chuta." Jaan chuta, I don't want to continue as secretary anywhere. Arey mere jaan chuta, itna problem aata hai. Correct? But please understand, when you say debar, it is not only in your society. Nowhere in the state of Maharashtra he can contest election in a cooperative society for a period of 5 years. Please understand. So when I say it's debarred from contesting elections, he cannot contest election in the entire state of Maharashtra for a period of 5 years. Yes. In elections, there are reservations which are given. One, to backward class and women. So in a cooperative housing society, out of the total strength of managing committee, 5 seats are reserved category. 5 seats are reserved category. 3 is for 1 scheduled caste, scheduled tribe, other backward class and special backward class. Correct? Scheduled caste, scheduled tribe, other backward class, OBC, special backward class, SBC. Correct? These are reserved seats. If these reserved seats are not filled, they cannot be converted into general category. If it is not filled, it will remain empty. It will remain not filled. It cannot be replaced by general category. Correct? Right? That is section 70B. New section 154B20 talks about reservation for backward class. 154B21 talks about reservation for women. Out of the total strength of the managing committee, 2 seats are reserved for women. Right. Now please understand, who can contest to a managing committee? Member. Please understand, member of the society. Correct? So a member of the society means you should have signed that agreement. Correct? Or he can be a provisional member, or he can be an associate member. Understand here? Correct? When I say member of the society, we said member includes who? Associate, joint, provisional. Correct? So member can be any one of these. Member of the person who has joined the agreement, associate member who has not signed the agreement but he is an associate member, joint member who has signed the agreement, or a provisional member, person who is nominated on account of death of the original member. All these can become members of the managing committee. All of these can become members of the managing committee. Now, women category, 2 persons can be women category. Their name should be there in the agreement, or should be provisional member, or could be a joint member, or could be an associate member. Correct? If he is an associate member, they have to obtain NOC from the original member for contesting the election. Again, if the women category is blank, it will remain blank. It cannot be filled out of general category. Reason is, section 73 very clearly specifies, 70B and 70C clearly specifies that reserved category can be filled out of the same class of member who is eligible to contest in that reserved category. So who is that class of member who is eligible to contest in women category? Only women. Correct? So if there is women category is absent, then it will remain absent. It will remain empty. It cannot be filled in general category. Correct? Clear? Elections to be done in your case since a society is more than 250 members, it has to go to SCCA, State Corporate Election Authority. A returning officer will be called. He'll do the elections. It is a 60-day process or a 45 days process, depending upon how the returning officer does the process. 60 days process. It has to have open ballot. There will be a ballot box where you'll have to, just like a Lok Sabha election, you'll have to come choose your candidate for the particular post. Correct? And in your case, since it is society is more than 500 members, 19, 11, 13, 15, 17, 19 members society. Correct? 19 member society. Out of 19 members, 5 is reserved category, 14 will be general category. Disqualification. Yes. Very important. Understand. Disqualification. Who cannot contest election or who once is elected gets disqualified. Both cases. A member of the society who is a defaulter. Please understand. A member of the society who is a defaulter. When I say defaulter means he is not paid dues of the society and a period of 3 months have elapsed from the date of service of bill or notice or payment of due date, whichever is later. Correct? So, in 3 months have lapsed. Society has raised a bill on 1st of January. 3 months have lapsed and he has not paid the bill of the society. And society has sent him a notice. Correct? So some societies what they do is, they mention the bill as bill cum notice. Correct? They mention the bill as bill cum notice. Correct? So it is a notice as well as a bill. Right? So the date of the notice and date of the bill is the same. Right? And they said the payment date should be 15 days. So 1st January they raise the bill, 15 days means on or before 16th of January you have to make payment of the bill. If you do not pay the bill and 3 months get lapsed, correct, from the date of bill or due date whichever is earlier, in that case what will happen is you will become treated as a defaulter. Once you are treated as a defaulter, you cannot contest elections. You cannot contest elections.
But you can still attend meetings and vote.
You can attend meeting and vote, but you cannot contest managing committee elections.
We have one question. He has defaulted in the payment. Later on he has cleared the dues. Still he will be remain defaulter or
no? He'll come back as clean.
So that means in the time period when election is about to begin and within that he has to be clear.
Yes.
Any old history of defaulter doesn't matter.
Then clear थी.
उसके बाद default किया, then issue notice. Correct? Please understand. Suppose you are elected as a member, right? What did I told you? This is disqualification of managing committee member. Correct? Prior to election or after being elected, you are still a defaulter. Managing committee. Managing committee has to lead by example. He has to pay first and then ask members pay. Correct? If he does not pay and continues to default, society managing committee has to raise an objection on that particular member saying that you have not paid for 3 months. So if you do not pay on or before this date, you will become defaulter. And once he becomes defaulter, he will be disqualified from managing committee. So what he will have to do? He has to immediately pay and then he will become taken back in the managing committee. Clear? Second type of disqualification is a member of the society is giving or is carrying on the business of giving flats on leave and license basis or selling flats in a society of which he is a member. That means basically a broker. If a broker is a member of the society and is dealing with the society, giving flats on leave and license basis or selling flats in a society of which he is a member, such a member cannot contest election, is disqualified from contesting election. Okay? Third type of disqualification is a member of the society who has failed to submit under section 79. 79 talks about returns to be filed. Correct? or action has been initiated under section 88. 88 talks about dissenting promoters, or 154B8 clause 2. Now I have discussed this 154B8 clause 2. Understand? There are many of you all having so many questions, right? There is something which is called inspection of documents of the society. Correct? A right of a member has a right to inspect documents. Correct? Now what documents can be inspected by a member is given in section 154B8 clause 1. Correct? Now what does 154B8 clause 1 says? What are the documents he can inspect? He can inspect the audited statement of accounts. Correct? The last year's audited statement of accounts. He can inspect the minutes of meeting of the managing committee, general body and special general body meeting. Right? He can inspect copies of the bylaws of the society, the registers of the society. There are certain mandatory registers which have to maintain. He can also inspect all those copies or documents in which his transaction is recorded. Please understand. That means if the member is Mr. A, he cannot inspect transactions done by Mr. B. He cannot ask from the committee, I want Mr. B's records. No. Correct? 154B8 clause 1 very clearly specifies what are the documents which he can inspect. It also specifies when a member has to inspect those documents. He says that member can inspect those documents free of charge during office hours of the society. Correct? During office hours of the society, he can inspect those documents free of charge. Correct? Or any other time when the managing committee tells him to inspect documents. He can come inspect documents. But if the member says, no, I want copies of the documents which I have inspected, then he has to give a letter in writing to the society. 154B8 clause 2 says that when a member of the society wants copies of documents which is inspected, then he has to give a letter to the society specifying what are the documents he wants to inspect. Once he gives the list of these documents he wants to inspect, the managing committee will find out what is the cost of these documents. All those things are given in the bylaws. Bylaws said, if you want a copy of the bylaws, 5 rupees per page. If you go to buy the bylaw in the market, you will get it for 60 rupees. 5 rupees per page, that is 120 pages, it will cost you 600 rupees. Correct? So you have to take a call. Take it from the society or buy it in the market. Correct? 5 rupees per page. If you want copies of the balance sheet, income and expenditure, again 5 rupees per page. Correct? So all these things it will cost. So they'll tell you, whatever these are the documents you have asked for, as per the bylaws, the total cost which you have paid to society is 1,000 rupees. Take 1,000 rupees. Within 45 days from the date of receipt of money, society is supposed to give those documents to the member. If the society fails to give those documents to the member, the person who is responsible for giving those documents, usually secretary, is responsible to hand over those documents. If he does not give those documents, then he will held guilty under section 154B8, disqualification. Clear? Right? So, right of a member to get information is a statutory right which is given in the Act.
But only those documents are being investigated, or the vendors thing, everything, monthly expense, all that can be asked by the member?
What they said, what did I tell you? Minutes of general body, minutes of managing committee meeting, income and expenditure account and balance sheet, last year's audited statement of accounts. Correct? These are the things which can help. Bylaws of the society, minutes of the members register, correct? All those statutory registers he can ask for, and all those transactions in which his transaction is recorded.
No, but other than that,
suppose he asks for, give me members' bills. Whatever he wants to ask, he has to see there. He can come to the society office and inspect all documents.
no, other than that, if the member wants, I want the housekeeping vendors all monthly expense documents, can he?
He can come check there.
the.
He can see and inspect. He cannot ask for copies. He can apply only those which I mentioned, not anything else. That particular year. He cannot ask last 10 साल का मुझे दो. It doesn't come within his purview also. Right?
There is a difference. Like inspection is something I take a copy of the document, I have to pay the charge, and I can get it in.
Inspection is you come see in your presence.
No,
That is inspection. What is inspection? Inspection is go to the society office, ask the society office, I want to check these documents, see the documents in the society office, inspection.
Then what is the other procedure?
Other process is ask copies of documents. Ask copies of documents is make a list of documents which you want.
Where the asker has to pay some cost.
Yes, the cost.
And in a return also he has to list down the name.
Yes.
Okay, one of the things that say if I'm taking any document, or if I'm asking for any document, and I paid the amount after I got the document. After that, it's my responsibility to not leak those informations to others or
Whose responsibility?
whoever is collecting the document. Or they know that.
It is
Mainly I'm talking about the transactions, right? So when somebody is asking for the transactional information, right? And if let's say if he is taking the printout and then he is taking the photo and circulating to let's say anywhere, right? So in that case, is there any law to prevent that?
there is nothing which says that. It is his. If suppose he has taken and given to his neighbor, or given to
Mainly let's say audit report.
taken the audit report, circulated among the members.
That's
All
all.
members. No issue.
Our accounts are not audited. Currently, we are in good society. Because the accounts are not audited.
So there won't be any audited income expenditure balance sheet which you have to give. So he will not inspect those documents.
So, any accounts related to.
He will come to the society office, he can check all documents, whatever he wants, but he cannot take any photo, he cannot take any, ask you for copies. Copies he can ask only which are specific. So during office hours, he can come and inspect free of cost. Inspect free of cost during office hours. But if he wants copies of documents, then he will be charged.
Okay, related to elections, I think one or two questions were there.
I'll just finish disqualification. So, disqualifications, the fourth type of disqualification is if a person has been guilty of a particular offence and there is a penalty on that particular offence, then also there is a disqualification which is covered on the section 154B23. The old section was section 73CA. Right? Bylaws, you've got bylaw number 117 which talks about disqualification. But the current 117 bylaws is slightly different from the old. It's slightly different from the new disqualification. Certain items have been added in the new. In the old, you did not have that dues of members was not there. Now the dues of members have been added.
That offense is what?
Which one?
Civil or criminal or?
That I'll come. I'll take it. Where a person has been held guilty of moral turpitude, correct? And he has been imprisoned for a period of 1 year, convicted and imprisoned for a minimum period of 1 year, then such a person cannot contest elections. Second, the person has got more than 2 children. Understand? Person has got more than 2 children. He or she cannot contest elections. He or she cannot contest elections.
Why
This came in effect from 7th of September 2001, correct? Lot of hue and cry was on this particular section. This is there only the MCS Act, correct? MCS Act. So matter has also gone up to Supreme Court level. The same of 2 children has gone to Supreme Court level. And in the Supreme Court level, Supreme Court gave an excellent judgments regarding these 2 children. So Supreme Court said, election to a cooperative society is not a fundamental right. Correct? It is not a fundamental right. It is a right under a particular statute. And that statute is Maharashtra Cooperative Societies Act. Statute can exercise restriction to whatever extent possible, especially if it is relating to family planning. Even if other legislations or other states have not passed such an act, if this particular thing is there which will promote family planning, in such a situation, the disqualification stays. It cannot be against Article 21 or Article 14 of the Constitution. Correct? Article 14 talks about equality. Correct? Saying that every person is equal. So, Supreme Court very clearly said it's not a fundamental right. Right in a Lok Sabha election is a fundamental right. Please understand. Lok Sabha election, it's a fundamental right. But right election to stand for election in a cooperative society, not a fundamental right. It is a right which is given under the Act. And the Act can restrict any person to any extent possible. Correct? So they said this restriction of 2 children is not against Article 14 or Article 21 of the Constitution. Disqualifications. When a person is disqualified, has any one of these disqualifications which I have just discussed? Leaving the first one was, what are the first we said? Defaulter. Leaving the first. If he has got any one of those disqualifications, correct? The society has to intimate the person concerned and also intimate the registrar. Registrar will do an inspection, and if he finds that disqualification is correct, then he will issue an order. He will become disqualified from the date of receipt of the order of the registrar. He will be disqualified for a period of 5 years. Remember, he will be disqualified for a period of 5 years, not for 1 year. He will be disqualified for a period of 5 years. Except in case of a defaulter, his disqualification will cease as soon as he is paid the money. He asked the question. Correct? So if a defaulter pays money, bearers. It cannot be against committee. You have elected the committee. You have elected the committee, understand? You have elected the committee. Tomorrow you cannot say, I have got no confidence against the entire committee. You cannot say that. Because you have done an election. Correct? So once you have elected, you cannot say, I do not have confidence. No confidence motion can be against office bearers. By whom? Only managing committee members. Managing committee can say that I have no confidence against office bearers. Similarly, just like Lok Sabha. Correct? Just like Lok Sabha. No confidence motion, we don't tell the public to pass no confidence motion. No. Only Lok Sabha members can pass no confidence motion. Correct? And that too against the Prime Minister. Correct? The same way, in case of a cooperative housing society, no confidence motion can be against office bearers. Correct? Now, there is a process to be followed. This is section 154B24. Correct? Section 73 ID of the old Act. The new Act is 154B23. Now, sorry, B24. Now again, there's a process. What is the process here? The process is, you have to call for a special meeting of the managing committee. Correct? You have to call for a special meeting of the managing committee. 1/3 of the members of the managing committee have to write a letter to the registrar asking him to convene a special meeting of the managing committee in order to pass a motion of no confidence against the office bearer. Suppose the motion of no confidence, they want to pass it against the chairman of the society. Let us assume. Okay? So they have to make, 1/3 of the members of the managing committee have to make a vote at the meeting. Okay? Once a special meeting has been convened, that meeting cannot be cancelled for any reason. There cannot be any change of hands between the chairman and the members. No. Once a special meeting has been convened for a motion of no confidence, it has to take its normal course. It has to be completed. Correct? It has to be completed. Minutes of the meeting should record the persons who are for or against the motion of no confidence. No motion of no confidence can be initiated against any office bearer unless he has finished 6 months in office. So in order to have a motion of no confidence against an office bearer, the office bearer should have finished 6 months in office. Whether he is chairman, secretary or treasurer, they should have finished 6 months in office, then only you can have a motion of no confidence. 2/3 of the members present in the meeting have to vote for motion of no confidence in order to be a success. Right? 2/3 of the members present in the meeting. That means, in the meeting of the managing committee, please understand, motion of no confidence is done by the managing committee members against its office bearer. It is not done by the members against the managing committee. No, it is done by the managing committee against the office bearer. The managing committee feels that, but we do not have confidence on the chairman or secretary or treasurer. Correct? So 2/3 of the members present in the meeting has to vote for a motion of no confidence. Once 2/3 of the members vote for a motion of no confidence, then the motion of no confidence is said to be a success. If it is a success, then the chairman or secretary or treasurer ceases to be a member of the managing committee. Correct? Correct? Ceases to be a member of, ceases to be chairman, secretary or treasurer. He will continue to be a managing committee member, but he will cease to be a chairman, secretary or treasurer.
Sir, what if this motion of no confidence asked by the committee against all the 3 CSTs, like chairperson, secretary and treasurer, all 3? So will there be a re-election?
Suppose you call for motion of no confidence against all the office bearers.
Not I call, the committee.
Suppose, I am giving an example.
Representative democracy is the right word.
So if the managing committee members call for motion of no confidence against chairman, secretary and treasurer, correct, all of them. And the managing committee, all the chairman, secretary and treasurer have been removed. No motion of confidence is a success. Then they will cease to be chairman, secretary and treasurer. Some other person will become chairman, secretary and treasurer from the same managing committee member.
But the managing committee's number has reduced, no?
He does not cease to be managing committee member.
Okay.
He just ceases to be chairman, secretary and treasurer. And when administrative. Once a motion of no confidence has been passed and it is defeated, another motion of no confidence against the same office bearer cannot be passed for a period of 1 year. Act says 1 year, bylaw says 6 months, Act will prevail because it will be written in bylaw. Yes. Any questions? Motion of no confidence? Disqualification? Question? Any questions on this? Yes, you had some question on election.
On election. So we talked about the caste positions, right? So let's say while doing the election, let's say if that person or the nominations is not there and hence it is blank.
Nominations, yes.
Right. And after election, if let's say somebody want to go for that position, so is it possible or not?
Yes. So that situation you have to, if a person gives an application, you have to take the application because that position has remained vacant. Take the application, go to the SCCA and tell the SCCA that now we have received this application, can you consider? It is all SCCA. He has to decide. So if the registrar says yes, I'll decide. He says yes, you can make him a member. Then he will issue an order, make him a member.
Second questions are related to this committee members.
Related to?
Committee members. So you talked about CST, so chairman, treasurer and secretary. But what about the other members? Let's say if we want to, let's say, because of XYZ reason, because of, let's say, no confidence or because of, let's say, something else, if committee want to remove some member from the 19 members, then is there any provision for that or not? No.
Democracy. We are a democratic country. He is elected for the people, by the people, of the people.
Okay.
How can you do it? You do not know unless it comes to this country.
So if you want, we can take 5 minutes bio break.
I am for break. Yeah. Next. We'll discuss all this. Manager organization best committee to first committee is defined means managing committee, committee member means member of the society. Exercise of powers will do everything, exercise all powers conferred on discharge of officer. Okay? Stop. Then the managing committee. Yes. Strength of the managing committee depends upon the strength of the society. Right? Understand? Strength of the managing committee depends upon the strength of the society. Right? Number of members in society. If there are less than 100 members, then you can have a managing committee of 11. 100 to 200, 13. 200 to 300, 15. 300 to 500, 17. More than 500, 19 members. Out of 19 members, 5 will be reserved category. 3 will be for backward classes and 2 will be for women. In the backward classes, quorum for the meeting is simple majority of members present. Please understand here. If the 5 members reserved category are not elected, correct? Let us assume in your case, 19 member society, 5 is reserved category, so 14 get elected. Correct? Now out of the 14 which are elected, what will be the quorum? The quorum will be simple majority of members present, excluding the 5. Correct? So out of the 14, the quorum will be simple majority. That will be the quorum for the managing committee meeting. Very important. The quorum of the managing committee has to be there for passing resolution in managing committee meetings. You have to see that all the quorum is present for passing a decision. Because if you do not obtain signatures of members in your managing committee meetings, and tomorrow there is an inquiry which is done with the registrar, and he finds, an inspection he finds, yes, there is no quorum, he will say, yes, this resolution cannot be passed. This resolution becomes invalid. Now there are many questions which are asked by members.
Sir.
In case of just give me 5 minutes. Members which have asked saying that, sir, in case of managing committee meeting, if a member is not present in a managing committee meeting and there is a resolution which is passed, is that member liable for any loss which society has incurred as a result of that resolution? You understand? What the question is? The question is, a resolution was passed. Correct? That resolution which is passed resulted in a loss to the society, say 10,000 rupees. One member of the managing committee, Mr. A, was not present in that meeting. Whether he is responsible for that particular loss which the society is incurred. You understand? The law is very clear. Members of the managing committee are jointly and severally liable for all acts which the managing committee does during its tenure in respect of all transactions which are detrimental to the interest of the society. So if there is a transaction which is entered into which has created a harm for the society, as a result there is a loss, then managing committee members are jointly and severally liable. But if a member does not attend a particular managing committee meeting in which this decision was taken, and also does not subsequently in the next meeting does not confirm that particular resolution, correct? That means he is not present in the managing committee meeting when resolution was passed. In the subsequent meeting when that resolution, when they were discussing minutes of the previous managing committee meeting, he says, no, I am not here at all, please remove my name. Tell that Mr. So-and-so is absent, correct? And he says that I am not there, and he does not confirm the minutes of the subsequent meeting also, then that member of the managing committee cannot be held responsible for the loss which the society has incurred. Now to determine whether the society has incurred loss which is detrimental to interest in society or not is not on the members. Members have to intimate registrar. Registrar will send a person for inspection. The inspector will come and inspect the document. He will give his report to the registrar. If the registrar finds that the loss which has taken place, it is reason beyond the control of the managing committee, then he will pass an order saying that managing committee is not responsible for the loss. But if he has got evidence in his possession saying that the resolution which is passed has caused a loss to the society, then he will tell the managing committee members, please bear that loss, recover the loss of the managing committee members to the society. Please understand, members of the managing committee are jointly and severally liable for all their acts which has taken place during the tenure of managing committee member, if those acts are detrimental to the interests of the society. It does not mean that every action which is taken by the managing committee is detrimental to interests of society. No. Correct? They have gone according to quotation. Suppose he has taken a quotation from 3 parties, he has selected the lowest quotation, he has given him the job, and that person is not doing his work properly. At the most he can say, I terminate your contract. You cannot hold the managing committee responsible. Aapne kyun galat aadmi ko diya? There were 3 quotes. I have taken the right person. I have taken at that time he is qualified in this. And he is the least. We have given him the quotation. He is given the quotation. He responded to the least. He came for an interview. He passed the interview. We discussed everything. All this was discussed. Now there is lethargy in that guy. Then in that case, managing committee will say, I can terminate his contract. Clear? Right? Next, yes.
On this board, I have a general question which might raise up things. Sir.
You continue.
No, it is much beyond this society and all. It will go to the Act 13B, like Maharashtra. Why is not physically handicapped persons reservation is there?
I will take your question. I can at the most pass it on to
can
the...
get accident, his leg is not there, but his mental ability can be above, like Stephen Hawking.
Yeah, you are saying why it is physical ability is not given reserved category?
Yes.
Physical ability not given reserved category?
Yeah, physically challenged person also should be given 1 seat at least. It will change the act. Maharashtra.
You have to apply. You have to take this with. You are asking right question, wrong person. You have to take it with the ministry. I can't.
So see,
we can at the most tell. Yes, your question is well taken, but at the same time, when they framed the act, why reservation? Why women? These questions were.
I do understand.
Why reservation? Understand this. Why reservation? Why women? These questions have been deliberated because the person was sitting in the helm of affairs in the ministry, the secretary, the IAS officers. They got guys who have got an extreme amount of knowledge and experience. They debate all these points to court. There was a question where previously society could not spend more than, now also you cannot spend anything in cash in excess of 1,500. Correct? Cash expense in excess of 1,500 you cannot spend. Many societies asked us, sir, अभी 2023 का जमाना डिजिटाइजेशन का जमाना है, अभी एक हथौड़ा लेके आएगा तो 5,000 रुपये का खर्चा आता है उसको, और वो कैश पूछता है, उसके पास अकाउंट नहीं है. So when we took, they said, why don't you make a representation? We took this, made a representative of the ministry. The IAS officer, you know what he said? He got up and he said, sir, you are talking from your level. Come to grassroots level. Why we have made 1,500? It's very interesting to know why we have made 1,500. The Prime Minister wants to introduce a position where even the person in the street can open a bank account and start saving. Nowadays a casual laborer takes money, drinks half the time hits his wife and ends up in jail, and next minute he is not earning, life is in the street. He said we do not want such a situation to happen. The person who is earning even the least, in a cooperative housing society, you've got a gardener, you've got a watchman whose salary is not too high. Correct? We want them to have a habit of saving money. So that's the reason we are saying, if it is more than 1,500, prepare a cross check, deposit it in his account. So that even if he earns 100 rupees interest, that 100 rupees interest has come free of charge to him, without even doing anything. So that's the reason. We wouldn't have even thought about such a thing.
So yeah,
so the extent of which I am saying their thinking goes. So probably when they would have discussed, probably the physically handicapped also they would have discussed at that particular point, and they would have said, no, physically handicapped person is only physically challenged.
Yeah,
but he has got certain amount of brains and things which he can definitely use. He can definitely participate in the affairs of the society, even if he knows physically. There are so many physically handicapped people who go to work even today. who are in topmost positions in bigger companies. So it is not necessary that a physically handicapped person should be given reservation. Probably they would have thought about this. In any case, we can speak about this to the
They
government.
can be
Let's-
considered in general.
Yes. Then next. Anything else?
Yes, sir.
Yeah.
Is there any prescribed number of meetings which to be conducted by managing committee?
One meeting every month.
One meeting every month.
Bylaw 127.
Oh.
One meeting every month has to be conducted. Yes, there's another type of disqualification. Yes. Quorum should be followed. One meeting every month, mandatory. Correct? Committee meeting. Now, there is another disqualification which comes there. If a member of the managing committee remains absent for 3 continuous monthly meetings without leave of absence, then he is disqualified from being a member of the managing committee. Please understand, operation of law. This is operation of law. If a member of the managing committee does not attend 3 consecutive monthly meetings, it does not mean if a society calls for 3 meetings in a month and he does not attend 3 meetings, it is no disqualification. 3 consecutive monthly meetings. So January, February, March. In all the 3 meetings he is absent without leave of absence. He has not given a letter. Like a school child, father has to write a letter of absence. No. Same thing. Member of managing committee has to write a letter and tell the secretary, I am not able to attend the meeting. Please excuse my absence. If he gives that letter, he will not be disqualified. Else, he will get disqualified if he does not attend 3 consecutive monthly meetings. Operation of law. 3 meetings are over, he does not attend. 4th meeting, he gets automatically disqualified. You have to just intimate him that you have not attended 3 meetings, now you are disqualified. Bylaw number 119. Right?
In that disqualification process, then do we have to hire the other one also in the managing committee?
Co-option. That I will discuss.
Not higher, means re-elect. We say question and
Now, in a society which is more than 250 members, you can co-opt 1/3 of the strength of each category. There are 3 categories: general, women, and reserved. Correct? So 1/3 of each category you can co-opt in a particular term. Correct? So in your case, 19 are there, 5 is reserved. That means 14 is general category. So 1/3 of 14, 4 people you can co-opt in case a person remains or gets disqualified or resigns and goes. You can co-opt 4 people maximum in the entire tenure of 5 years. Co-opt means person is elected. I get elected to the managing committee.
You mean to say backup?
I get elected to the managing committee. Then, after 1 year, I get transferred to, say, Delhi. I get transferred to Delhi. So I will not be able to attend the managing committee meeting. Correct? So what I will do, I will resign from the managing committee. So there is a vacancy which is created. That vacancy can be filled by co-option. Correct? So the managing committee can fill that vacancy by co-option. So the rule of co-option is 1/3 of a category of person, a category of a class of people can be co-opted over a period of 5 years.
So they have to come by election.
No. So whenever there is a vacancy, you have to intimate the State Cooperative Election Authority, and you also have to put a notice on the notice board. Correct? Then once you put a notice on the notice board, there will be people who contest. If there is only one person who comes forward, you just give his name to the State Cooperative Election Authority saying that he has come forward, we want to co-opt him. Gets co-opted. If there are more than one person, there are 5 people who come for one post. Correct? There is one person, 5 people come. You intimate State Cooperative Election Authority. State Cooperative Election Authority will say, wait, I'll send the returning officer, we'll do an election. We'll then elect out of that 5 one person. Yeah.
One question there. Like if someone is resigning, we already have a backup which are already resigning in our society. So can we not elect someone from there?
You've told me don't tell anybody else. You cannot.
Okay.
You cannot. No backup. No battery backup. So there is gone is gone.
So the ideal way is to for
If the notice is not displayed, if suppose example one vacancy is there, but it
You have
has
to
not been
intimate the
notified.
State Corporate Election Authority and you have to notice in the notice board.
And
So that people come. Or what you can do is send emails saying that such and such thing is there. If you do not do it, you can just go to the registrar and say, sir, उधर vacancy हम लोग notice नहीं करता. He will send a letter. Vacancy नहीं करो. Everything is the registrar is the person. Yes.
So can we expect a reply from the registrar, sir, if any letter has been dropped? If any letter has been dropped to the registrar, can we expect a reply from the?
Yes, why not?
Most of the cases, government employees will not be.
No, registrar is very proactive. So the best way of doing it is, I'll tell you, best way of doing it, we tell this to everybody, saying that whenever you write a letter to the registrar, write down below, CT. A resolution passed in the general body. Resolution passed in the general body cannot be changed unless 6 months are elapsed. So once if you have to revise the budget, you have to revise the budget only after 6 months. Till the time you can. Transfer. Now regarding transfer, a member of the society can transfer his interest. Member of the society can transfer his interest, right title and interest in the property to any person only by way of a registered document. Right? A member of the society can transfer his right title, interest in property in the society only by way of a registered document. Correct? He cannot transfer. When I say registered document means there has to be an agreement for sale or a sale deed. It has to be stamped and registered. He cannot use power of attorney and transfer. He cannot say I will pay stamp duty now, register में 1 साल के बाद करेगा अभी transfer करो. No, you cannot accept. It has to be only by way of a registered document. So there is a process which is to be followed. Correct? Once the process is followed on transfer, member has to give 15 days notice of his intention to transfer to the secretary of the society. Along with that, he has to give the consent of the transferee. That means the new member who wants to become a new member, he has to give his consent that person wants to become a member of the society. He has to give set all the transfer documents, plus he has to give the registered agreement, plus he has to pay 500 rupees transfer charges, 100 rupees entrance fee, 25,000 rupees as premium on transfer. Once this money is received in society and the society finds there is no problem in the transfer, they will place it in the monetary committee meeting and initiate transfer. Correct?
There is something of the gift deed or
gift deed.
So before that, this
Gift deed is to be registered, sir, by paying stamp duty.
So is 25,000 is fixed, or it is as per the locations of
25,000 is fixed. No location. 25,000 fixed. 25,000 stands. Prior to 2014, there was difference between purchase price and sale price. Now it is 25,000 fixed. This transfer. Correct? In gift also, there is a gift. Gift is also a transfer. Please understand. Gift is also a transfer. Correct? So when a person is giving gift, you will give gift only to your near and dear ones. So a gift also has to be a gift deed. It also has to be stamped and registered. Only thing is, you don't have to pay 25,000 rupees in a gift deed when you are gifting to your near and dear ones. That 25,000 you have got to pay, only 100 and 500. Next. Next. And so on there. Yes. Now I'll do this along with nomination. Now understand. Very interesting. Transfer on death, nomination. 154B13 talks about on death of a member. Please understand. On death of a member, the right title interest in the property is transferred to the persons who have submitted testamentary documents or succession certificate or inheritance certificate or legal heirs of the deceased persons, and those documents are executed by the persons who are entitled to inherit these properties. Correct? Remember. That means when Mr. A dies, A member of the society died. His right title interest in property can be transferred, understand, can be transferred to either Mrs. A if Mrs. A produces an inheritance certificate or a legal heir certificate or a succession certificate. Please understand. It cannot go to Mrs. A just by Mrs. A saying, I am the legal heir, mujhe transfer karo. Nahi. There has to be a document only based on, it's very clear, based on testamentary documents or succession certificate or inheritance certificate or legal heir certificate. Only if these documents are present, then only it can be transferred to the legal heirs. It can be transferred to Mrs. A. Correct? When there is a succession certificate, so if Mrs. A gives a succession certificate or legal heir certificate, then the ownership, please understand, ownership gets transferred to Mrs. A. But if Mrs. A is not in a position to give succession certificate and Mr. A before dying, he has made nomination in the name of Mrs. A, then in that case Mrs. A will become member or provisional member but not owner of property. Please understand. Even if she is Mrs. A, understand this, clarity should be here. On death of a member, death of Mr. A, Mrs. A cannot claim to become owner of the property without testamentary document, without succession certificate, without inheritance certificate, without legal heir certificate. Only when she produces these certificates, she will become owner of property. Suppose she does not produce these certificates and Mr. A has made her a nominee. On the death of Mr. A, Mrs. A will become provisional member, temporary member till she brings these documents. Correct? So after becoming, if so a person on death, property is transferred to the nominee, she will become only what? Temporary member, provisional member. He will have only membership rights. She will not have ownership rights. Please understand. There are many questions come from many people who have said, sir, nomination mein, there is Supreme Court case, Indrai Wai's case, that very clearly says, nomination mein, the person whose nominee becomes owner of property. Answer is no. Supreme Court has very clearly said in Indrani Vai's case that in case of nomination, society only mandates, correct, that the property should be transferred in the name of the nominee. It does not state that the ownership will be given to the nominee. Correct? So in a nomination, only membership right is transferred. Correct? Ownership right is not transferred. Ownership right is transferred only on succession certificate, testamentary document, inheritance certificate or legal heir certificate. Clear? Understood this? So when I say nomination, when you talk about nomination, who can nominate? Any member of the society can nominate. So if Mr. A is the owner of the property, Mr. A can nominate any person. Correct? He can nominate any person to be a member. Correct? When Mr. A can nominate any person, and I say he can nominate any person means he can nominate Mr. A, he can nominate Miss A, he can nominate Master A, he can nominate X, Y, Z, whoever he wants.
Don't make that sense.
Correct? He can nominate any person. Correct? But when there are Mr. and Mrs. A, understand? Mr. A is joint owner, Mrs. A is also joint owner. Mr. A is primary owner, Mrs. A is secondary owner. Then who has to nominate? Both of them have to nominate. Mr. A also has to nominate, Mrs. A also has to nominate. Both have to give two separate nomination forms unless their nominee is common. If their nominee is common, they can give one form signed by both of them. But if their nominee is different, both of them have to give two separate nomination forms. But both have to give nomination forms. So when there is a joint ownership, just give. If there is joint ownership, Mr. A and Mrs. A are joint owners of property. Mr. A has nominated Master A. Mrs. A has nominated Miss A. Mr. A dies. Correct? Master A will become provisional member. Mrs. A will become one member, original member. Master A will become provisional member. Correct? So out of Mrs. A and Master A, anybody can contest the election. Anybody can contest election because provisional member is also member. Anybody can contest election. Anybody can attend general body meeting. Clear? But Mrs. A cannot sell the property, cannot create third party rights, third party liability on the property unless legal heirs are brought into books. Mrs. A cannot claim saying that अरे ये तो मेरा ही लड़का है, आपको क्या प्रॉब्लम है मेरे को सेल करने में? प्रॉब्लम है, आपका लड़का है, हम सब जानते हैं. But in the eyes of registrar, in the eyes where you got a document registered, there Mr. A and Mrs. A have signed. Master A has not signed. So in the eyes of law, he is still not owner of the property. To become owner of the property, Mrs. A has to go and get legal heir certificate, saying that we are the legal heirs. So in that case, you can make Master A also the owner.
If there is a will, sir, can we consider the document?
Will, yes.
Document of family arrangement.
But document of family arrangement or will can be considered. However, what you have to do is go to the court, get the things started. That process you have to.
So this certificate is done from the registrar?
Not registrar, court. That's the reason we say that all nominations nowadays I always used to tell people, when you are crossed 50 years, prepare a bill. Now I tell them, you are more than 35 years, prepare a bill. Because 35 में भी pressure बहुत आता है. So 35 years होता है, I tell them, अरे bill बना के रख दो. Easier. Yes.
Double nomination is there, 50-50. On the disease of the owner.
One of the owners.
There is one owner and there are
two nominations. Yes.
And equal proportion.
Correct.
What happens
both the names will come in the share certificate. So the share certificate.
But they are still not owners.
They are still not owners. Remember, there is a difference between. There is something here.
No.
Sir, I was thinking about a twisted scenario about on the previous.
Sir, personal बातें करना. I'll just finish. Then
No.
discuss.
It's a case study for you.
Case study. Done.
Consider Mr. A. He died due to age.
He died due to old age.
Yeah. During the time of property purchase, he was the sole owner. But Mrs. A furnished her legal hire, all those testamentary documents, and she is the next owner of the property. But before dying and when the society was forming, Mr. A had nominated his son, Master A. Okay. Now, as per his nomination, Master A is becoming provisional member, but he has not got any letter, like NOC letter from the actual owner now, which is like Mr. A died, so Mrs. A is the owner now. So
you said that Mr. A died, Mrs. A got testamentary document?
So she is the now next owner.
So once Mrs. A has got testamentary document, based on the legal heir certificate, if the legal heir certificate says that Mrs. A is the owner of the property now, Mrs. A will become owner of that particular flat.
So what about
till that time the testamentary document comes, the nominee, Master A, correct, will become member, provisional member. But once the ownership documents comes, that is the legal heir certificate comes and says that yes, Mrs. A, Master A, Miss A, all are legal heirs of the person, all their names will then appear in the share certificate as legal heirs. Correct? Then all their names will appear in the share certificate.
So still the authority goes to Mrs. A only, right? Because she has to release a NOC letter that on my behalf, let the son also join the member meeting, general body meeting.
Don't confuse meeting. Now,
or the election.
You don't confuse election. Become member or owner. वही देखने का. Correct? Ownership. You have to see ownership. So on the death of Mr. A, if Mrs. A has brought testamentary document, that is, she has brought legal heir certificate, and legal heir certificate says Mrs. A, Master A, Miss A are the owners of the property. All the three names will appear in the share certificate.
So how does that process happen? Like the
Court.
transfer document.
Court. You have to go to the court. Right? So till that time he goes to the court. Now he has already appointed Master A as his nominee. So till that time that testamentary document comes, Master A will become provisional member. Once testamentary document comes, then all these three will become owners of the property.
Thank you, sir. Thank you, sir.
Yes, next. Yes, this is nomination. I showed this nominee and legal heir. Please understand. The same thing was happened in whatever he said now. Same, whatever he discussed now. Exactly same or something very similar was Indra Bai's case. Correct? In Indra Bai's case, is the case of West Bengal Corporate Housing Society. The father had nominated the daughter. So there was a fight between husband and wife. So wife and son separated, father and daughter separated. Father nominated daughter. On the death of the father, society gave membership to the daughter. Correct? Based on nomination. Wife and son filed a case saying that we are also legal heirs. हमारा नाम पे transfer करना चाहिए. So this matter went up to Supreme Court. Supreme Court said society has to only follow what is given in the nomination, what is mandated in the nomination. If nomination says daughter has to be made member of the society, daughter will be made member. This legal case which they are talking about, legal heirship, that is a different fight which they have to take to the competent court. That competent court will decide if they are legal heirs, the court will decide. And once the court decides they are legal heirs, then all the three names will appear. So till that time, membership right has to be given only to the nominee. Indra Bai's case. Okay. Next. Offences. I told you there are plenty of offences and penalties. Transfer of property at debt due to the society without permission, imprisonment for 6 months or fine of 5,000, fails to pay deducted amount that is not concerning society, fails to invest funds of the society. You are collecting sinking fund, repair fund, repairs and maintenance fund, education and training fund. Correct? You have to invest in fixed deposit. If you do not invest, 5,000 rupees fine. Please understand. Right? Secretary. Collect share money, does not deposit in bank, collect share money, issue a false certificate that he is not a defaulter, imprisonment will take 3 years or fine of 15,000 or more. Non-compliance section 75, section 75 talks about returns to be filed, 5,000 rupees. False return 75, 79, information 5,000 rupees fine. Next. This is just for information. Next. Next. Others. Affiliation. Society has to become mandatorily a member of Thane Housing Federation. You have to become member of Thane Housing Federation. You also have to become member of Thane District Central Corporation. Member. आप account खोलेगा, you don't become member. When I say become member, you have to take share. At least one share in the respective institutions you have to take. Funds and type. So there are creation of funds. There is sinking fund, repair and maintenance fund, major repair fund. You have got education and training fund. Sinking fund, 95% of cost of construction certified by the architect. Repair and maintenance fund, 0.75% of cost of construction. Major repair fund as decided by the general body. Education and training fund, 10 rupees per member per month. Yes, utilization of fund. Sinking can be utilized only for structural repair with approval of GB. Reserve fund for repairs of society, education towards such type of training which I gave. Investment, section 70, bylaw number 15. Yes, investments of funds of the society. All funds of the society which is not deployed, correct, has to be invested. Mandatory provision, please understand. All funds of the society which is not deployed, not used, has to be invested in fixed deposits or in the mode specified in the section 17. Levy of charges, I think all this is known, I'm not going through this in detail. You want to ask any question on levy of charges, you can ask. I'm not going in detail, I think you have got an excellent property manager, so all this is taken care. Next. Maintenance of books of accounts. Next come. Audit, yes. As I told you, audit is mandatory under the provisions of the law. Correct? Audit is mandatory. It has to be audited by a person who is appointed, who is a member or a panel member of that so-and-so. Chandrasekhar Iyer is registered here, his empanelment number is so-and-so. Only such persons you can appoint as an auditor of the society. Okay. Cash expenses, maximum 1,500. Limit for holding cash, maximum you can keep cash with your possession, 5,000 rupees if society. On receipt of the complaint, the society secretary has to place it before the managing committee and then intimate the member concerned within 30 days of receipt of the complaint what action the society intends to take in respect of the complaint which he has received. Now, if the society is given such a reply and the member is still not satisfied, correct, with the reply which is given by the managing committee, then the member can go to these people: registrar, cooperative court, civil court, municipal authority, local police, general body, district. These are the persons whom they can approach. Now please understand, even though we have mentioned these 7 bodies which can approach, the complaint depends upon, the type of complaint depends upon where he has to go. If there is a theft in his,
has been reported in this building,
if there is a
cease operations and leave the building,
if there is a theft in the society,
stairs. Repeat, do not.
If there is a theft in his particular flat and he wants to make a complaint, he cannot make a complaint. If there is a theft and there is a complaint which is to be done, he cannot make a complaint to the registrar. Correct? Registrar will say, I have no jurisdiction to this type of theft. Correct? He has to directly go to the local police. Correct? Similarly, if there is his neighbor has taken some place of his particular flat or extended his flat slightly ahead. Correct? Encroachment. Now such type of encroachment, he'll come to the society. Society will say, okay, we'll go and tell the member concerned, please cancel all this, remove the encroachment. If the member still doesn't listen, society has to approach who?
Cooperative court.
Cooperative court. You'll first go to who? Local authority, municipality. You'll first make a reference to municipality. If you go to the cooperative court will say, "Pehla channel mein aao na. Who's there before me? Before me is municipality. Pehla municipality ke paas jao. If municipality does not do anything, then you come to me. Then you don't go to cooperative court, you will have to go to the civil court. There you have to file a complaint saying that we are doing so many activities. This guy has not yet removed the encroachment from his place. So, whom to address the complaint is also a very important thing. Correct? Depending upon the type of complaint, you have to approach these 7 bodies, redressal complaints.
Is there any matrix kind of?
This is the matrix.
No.
What is to be addressed here?
No. Matrix as in which type of complaint? To which channel?
Yes. That is given. It is given in the bylaw. If you see the bylaw, to the registrar, what are the complaints which can be taken? What are the complaints which can be taken to the cooperative court? What are the complaints to be taken to civil court? Everything is mentioned.
What is that section or?
In the bylaw, it is bylaw 173. Next. Conveyance of property. Yes. Now, very important. I'll just give you a gist. Conveyance of property, I said, you are a, what type of society?
Tenant and cooperative.
Correct. Tenant co-partnership society, where the land and building does not belong to the society. Very important to get the property duly conveyed. Now in such a situation where there is no conveyance, you can either go, you can approach the builder and ask the builder, please do the conveyance. Now for reasons beyond certain reasons, the builder doesn't do conveyance. Why? He got various reasons for not doing conveyance. He can use your land or amalgamate your land with somebody else, with the adjoining society land, and he can take better FSI. Correct? All these things he can do. So all builders usually delay conveyances for certain reasons for their own benefit. Now in such a situation, society has got an approach where they can go to the court. Not giving conveyance by the builder is a criminal offence. When I say it's a criminal offence, we can bring the builder, take him to the court, and we can get him arrested. But we always say, is that a right approach?
The nearest exit or
Is that a right approach? Whether we should go to the arrest the builder, after he gets released or he obtains a bail, he still continue for not giving you conveyance. Correct? So the best approach would be ask the builder to come forward for doing a conveyance of the property. The cheapest and the best method of conveyance. In case of conveyance, what we do is we get the entire land and building transferred in the name of society. And since yours is a new society, all agreements will be stamped, duly stamped and registered. So in your society of your size, 100 rupees per member as stamp charges and 30,000 rupees registration fee if you do conveyance to the builder. Plus whatever your advocate takes those charges, that will be the cost. But if the builder still refuses to give conveyance, there is a provision in the act called deemed conveyance. The provision in the act called deemed conveyance. Now, understand this deemed conveyance concept with reference to member. Suppose there is some person, Mr. A, wants to become member of the society. Correct? He has purchased a flat. Society is already registered, he has purchased a flat. At the time when he is entering into his flat, he sees the secretary, and secretary के साथ झगड़ा हो जाता है. So secretary also ego hits him, and secretary says, इसको तो member बनाना ही नहीं मुझे, कुछ भी करने दो. So उसने document वगैरह लेके आता है, he submits to the secretary. The secretary says, नहीं इसको member नहीं बनाना, he is too harsh, he is disobedient, ये वो करके. So he says that इसको member नहीं बनाना है. What the member does? He pays the stamp, the registration, the transfer premium. He pays 500 rupees. He pays 100 rupees. He gives the documents to this society, the managing committee, gets it stamped. He waits patiently for 3 months. Society secretary says, no, isko to member banaya nahi. After 3 months, what he does is, he takes the document which he has submitted, copies of the documents, go to the registrar and gives it to the registrar. The registrar will immediately issue a letter, call the secretary and tell the secretary, 3 months have lapsed. You have not made this person a member of the society. Under provisions of section 22(2), he becomes a deemed member. So how you become a deemed member? Only on the order passed by the registrar. Similarly, how will you get deemed conveyance? Only on an order passed by the registrar. So in a deemed conveyance process, the registrar goes into the shoes of the builder, he goes into the shoes of the landowner and signs the document of conveyance in favor of the society. So one signatory is the registrar, other signatory is the office bearers. Correct? So if your builder is not doing conveyance, there is a process of deemed conveyance, but this deemed conveyance process is slightly expensive. In your case, minimum they charge 15,000 to 20,000 rupees per member in this deemed conveyance process. Especially in case of old societies. New societies, documents are available, therefore the process becomes easier.
So what is the tag for the builder?
What is that?
Yeah, I was also...
Builder, I told you, 3 months from the date of registration of the society, he is supposed to get the documents transferred. MOFA, members, ownership of flat act. Within 3 months, section. Conveyance, within 3 months of the date of registration of the society.
Sir, but for such a smart city, 3 months will not be possible.
Smart city or no city?
No, it's not a smart
We
city.
have said that unless until federation is formed.
And who said? Builder said. No, law this says different. Law is very clear, 3 months of the date of formation. Ask for document.
So ideally the next step should be, we should write the registrar.
Not registrar, write to the builder first. Sir, please do conveyance. Builder definitely starts with the process.
No,
He has to start.
If he is giving the date, saying like I will do the conveyance after a year.
After?
After a year. So let's say you have asked and I replied saying like okay, I will do the conveyance after.
So after a year approach, तो tell him, sir, year के बाद आप conveyance दो, मुझे कल ही deed conveyance sheet बना के भेज दो. हम लोग तब तक go through करेंगे. Go through करो, prepare the document, keep the document ready. But see that you get conveyance, very important.
He was mentioning about 4 clusters together and then he will convey.
That is his call.
So that is
The law is different. The law says within 3 months, date of registration. So that's why I said, object clause of the society, if you see object clause, object 5 of bylaws of society, the first object it says, obtain conveyance of the land and building from the builder of children. First. You have to get land and building conveyance. Understand here, please understand. Yours is a smart city, correct? Everything is good. Buildings are good, builder is good, developer is good, buildings are good, construction is good, everything is done. Let us take an example, there's an earthquake. Correct? Building falls. Entire building falls to the ground. Correct? 5 years are over from the date of construction of the building. 2 years builder has maintained. 1 year you have maintained. 3 years are already over. Correct? Earthquake has hung. Entire building falls. People will say, sir, हमारे पास तो insurance है. अरे, insurance में पैसा मिलेगा, building मिलेगा क्या? Tomorrow that landowner, if God forbid, if the builder is a landowner, he will cooperate and say, sir, हम reconstruct करके देंगे. आप insurance का पैसा मुझे दे दो, हम reconstruct करके देंगे. But if the builder is not the landowner, and the landowner is a separate person, today he would have become smart. You know, say, अरे builder ने इतना करोड़ों पैसा कमाया, अभी मेरे को चांस है कमाने का पैसा. तो ये से मेरे को 2 करोड़ रुपया दो, तब तक land transfer नहीं करेगा. Please understand, you are on a catch-22. You have to obtain conveyance. People say, tell me that, sir, we have got insurance. अरे insurance में पैसा मिलेगा, building नहीं मिलेगा. If the land is the name of the landowner, and if he refuses to part with that land, which he may not be able to do because there is an agreement which he has signed with the builder, but he can always bring some spokes into it and delay the process. So it is very important that conveyance is done.
And what kind of owner is builder?
If builder is the owner, very good. The builder will do the construction for you. But always see that there is a timeline of 4 years. If he has to construct a building of this size, it will take minimum 2.5 years for to construct. Till that time, where will you all go? If he is to...
Is it binding that if he is not conveyed, he has to do it again?
Not binding, no? That's what I am saying. It's not binding on him.
That will be covered under commercial discussion, sir. Whether it will be mutual understanding between the builder and the...
Correct, but understand here, it is not binding on him. Tomorrow he may also say, "Nee, abhi मेरे पास पैसा नहीं है to reconstruct, or I do not have the people to reconstruct." He is doing some other project, or he has left your project and you have left your cluster and gone to find a place where they can stay. So conveyance is very important. You have to do. There is very interesting case that was in Andheri. There's a building. So that building was 30 years old. So they had come to our office, to Mr. Ramesh Prabhu's office, for getting the deemed conveyance. So he prepared everything and said, yes, this is what the fee is. We will do this deemed conveyance for you. They said, "Arey, fee thoda zyada lagta hai." So they said, let's go get a second quote. So they went to another person to get a second quote. That guy's fees are a bit less. So they went to that guy and said, okay, you do it. But in the meantime, building will be up. So they again came back to, that fellow said, "Arey, abhi kuch nahi kar sakte, building gir gaya tumhara." So again they came back to Ramesh Prabhu. So Ramesh Prabhu said, I can't do anything now. What we can do is, we can at least speak to the builder and to the landowners to see that the construction takes place faster. Till that time, you will all have to take accommodation separately. So they all had to be take accommodation separately. Another 4 years went for redevelopment. So it's a process. So that's the reason I tell everybody, try to do conveyance as fast as possible.
Anyways, if conveyance is done, people will have to visit this place.
But at least one phase you have got, the land and building belongs to you.
At least that belong to you.
Yes. Ownership is there.
But in that case, I can ask or I can choose any other builders to do the construction. Right?
Yes. If you have got conveyance already, you can definitely ask somebody else. Yes. Next. Conveyance. Documents. These are documents. Next. I am not discussing much about conveyance because it will take 2 hours more for me to discuss the entire process. Thank you so much. I had a nice time.
Thank you, sir. Really liked it.
Any queries? 10 minutes, 5 minutes, queries?
Sir,
I can relax.
are there any tenant rights in terms of the flat? Like, in case they are staying in the flat, are there any tenant rights?
No,
that we need to be
tenancy,
clear?
tenants. No, there is a concept, in the old bylaws, there is a concept of nominal member. So once there is a tenant who is being, comes in the society on leave and license basis, then you will have to see that he is being paid as a nominal member.